My lord, may I need to mention for upgradation again motion for ingress exist totally blocking my lord on the land of the PWD.
Give the line.
My lord, may I be
My lord,
permitted to
may I-
mention for upgradation?
My lord, for upgradation.
My lord, may I be permitted to mention for upgradation because of my lord, subdivisional magistrate passed the order of demolition to demolish my old structure on the basis of assumption that my structure is on the road, one wall of the road.
You have
My
a
lord,
you have a right of appeal, sir.
no,
There's
my lord, because of my lord, subdivisional magistrate passed the order without inquiry and also without
right,
issuing any notice.
right of appeal against that order. So
I know it very well, my lord, but that is under section 133 CRPC. But without servicing any notice, without making any inquiry on assumption basis, on the basis of the allegation made by the third parties, he passed the order of demolition. My lord, that is subject to Article 226. Honorable High Court has the wider power and jurisdiction, my lord, to interfere with the order passed by the landed magistrate.
not
Let it be, my lord, appear on upgradation on urgent basis.
My lord, I am praying for upgradation, my lord.
My lord, may I permit?
I've told you, yes.
My lord, mentioning one matter my lord, for upgradation. It is a US proceeding pending since 1980. Final statement was issued in the year 2012. Appeal is pending since 2012. A fresh report has been submitted by the authority that I am not holding any excess vacant land. Still, the appeal is not being disposed of. Filed a writ for an expeditious hearing of the appeal in view of the latest
This is
report.
under the Land Reforms Act.
Yes, sir, you will see.
Yes.
Land ceiling act. Urban land ceiling.
Urban land ceiling is a specified act as so long as I can recall. Does this court have jurisdiction? Please check and find out. If it is a specified act, this court will not have jurisdiction. Please find out.
This has jurisdiction.
It is a specified act, the Land Ceiling Act, Urban Land Ceiling Act?
I shall have to.
I think it is a specified act. Please find out from the West Bengal Tenancy Tribunal Act. If it is a specified act, this court will not have jurisdiction. Please find out and come back.
May I?
My lord, a
may I
statute-
permit
my-
to mention for-
My lord, a stat.
This matter was earlier appearing as item number 45. Now it is appearing as item number 808. The urgency is that private respondent has erected a construction upon the government land, which has hampering my ingress and
Give the number. Give the number.
My lord,
My lord, a statutory departmental appeal is pending before the a statutory departmental appeal is pending before the district land and land reforms officer, and the appeal is pending for 6 months, last 6 months, and the date is not being given. That the subject property of the land is already being sold off. I am the developer. I am incurring huge losses, my lord.
District Land and Land Reform Officer, that indicates that it is under the Land Reforms Act.
My lord, this is coming under Group 1, my lord.
Is it under the West Bengal Land Reforms Act? This court will not have determination.
My lord, it is already running in the
One
list.
doesn't include all land matters.
So they can all land.
Please find out. If it is under the Land Reforms Act, this court will not have jurisdiction.
My lord, actually, the mutation was cancelled by the below
I
concerned
can
officer.
understand what you're saying. I can understand your case, sir. So that's why I say this mutation case, cancellation pending before the DLLR, this court will not have jurisdiction.
Actually,
Please
they are
find
not
out.
giving the date for the appeal. That is what.
This court will not have jurisdiction. It to be mentioned, Rakun. I have to release the matter.
my lord, may I permit it to mention, my lord?
From the honorable court, but the state respondent, despite granting mutation, has taken illegal possession. Is a hearing matter, lordship?
Salt Lake property.
No.
Then? Yes, any property. Give
My lord, may I permit it to mention, my lord?
New
For
motion, my lord.
upgradation?
For what? What is your-
Because mining lease was been taken, but it was expired during the COVID period, and it was not been renewed by until or considered till now. So kindly, this is in monthly list for
My lord, my lord, I have all the respondents, my lord, learned advocate, my lord, for inclusion of the hearing. Earlier application,
Affidavits
I,
are complete?
yes,
Affidavits are complete?
yes.
My lord, may I permit to mention
Here
new
you-
motion, my lord.
But again, that item, my lord, 549 of the online list. Last question matter taken up, not something again. I have served in on my land, my lord. It's a government land on a private respond, I have consumed the house.
Service complete?
Yes, yes, everything. has-
Give the number.
May I permit it to mention, your lordship?
My lord, upgradation.
For what? What
My
is your
lord,
urgency?
confirmation of the representation.
What is your urgency?
Unauthorized encroachment by the private respondent on the private public land.
Give the number.
May
My
I
lord,
permit
new
it to
motion, my
mention,
lord. These two matters was wrongly included before the Honorable Justice Samita Sinha
and a lack of jurisdiction, his lordship release the matter. Therefore, my lord,
New
kindly.
motion.
May I permitted to mention?
My lord, this is a restoration application, my lord. Mr. Mukherjee.
Lordship, this is your lordship's order, some portion of the building has been demolished. Now the rest portion is still there, but according to the PWD authority, this is not within the PWD land. This is the issue in this.
You have
This is a
challenged
new
that?
motion. I'm praying for upgradation.
Give the number.
Lord, I am mentioning one matter for inclusion of your lordship.
I think I've taken sufficient matters for it.
My lord,
My lord, this is a group.
Extension of interim order, contempt, give these applications. Restoration-
It's a group seven. I have inquired.
One application.
Extension contempt.
Number 997. Because running that is the sublimated area. My permit has been renewed up to 2027. And the third one also duly contested. Now the like secretary made by a letter under the issue. And the operation of the vehicle is kept in the box. As a result, my vehicles have been died.
The number.
The number.
But upgradation regarding the unauthorized construction.
Come back up after it. Yes, madam, you have been waiting for a very long time. Yes.
my lord, I can respond same, like illegally removing soil and bricks from the private petitioner's land. The complaint has been made, the Panchayat authority is not taking any step.
Give the number.
But
My lord,
My lord, may I be permitted? to open a
I
matter
prayed
for-
for upgradation in this unauthorized construction.
This is the last matter.
my lord, may I-
My lord,
Yesterday I was
The
there.
matter-
Yesterday I was here, but new motion.
what is your urgency?
They have included the PWD land, just in front of the house of the petitioner.
Give the number.
Your lordship, the matter.
My lord, these are
The matter
restoration
mentioned-
application, my lord. Who is saying restoration?
My lord,
Restoration
yes, my
application? Give the
Your
number.
lordship, the matter I mentioned.
Matter which was appearing in the list of the fifth, my lord. Subsequently, it was not appearing.
Remaining mentioning matters will be taken up tomorrow.
But
My lord,
Extremely
Lordship-
urgent, my lord.
One day you can wait, madam.
Your lordship, the matter I mentioned.
I can take up more than all these matters in a single day, not possible for me.
Lordship,
So tomorrow he'll be 82 and another 1 year old. Come back tomorrow, please.
your lordship.
It's all the days list.
I'm
Lordship, for-
mentioning one matter for inclusion of your lordship.
Item
I'm
one,
following the days list. Wait,
Item one.
Come back.
If it is not pending, well, only for inclusion, well, kindly take up.
Please come back.
Well, yesterday I was the have written that.
Item number 1, who is appearing? Item number 1, who is appearing? Item number 1, who is appearing? I have already stated, I will not take any more mention.
item number one, we appear.
Your lordship,
One, that matter has been disposed of, your lords.
That is what is what.
Yes, ma'am. The last order, last part one matter.
Yeah, এটা কেন এসছে to be mentioned? Evidence service not found service এসছে তো আসছে। বলে দিন ওদেরকে ডেকে যেটা যেন না আসে আর এভিডেন্স সার্ভিস তো দেওয়া আছে যে ওখানে একটা তো আছে ওরা কি ভাবছে আমার কোনো মাথা ব্যথা নেই ফেরত পাঠিয়ে দিন বলুন এটা যেন আর না ওঠে দরকার নেই কিছু অর্ডার ফেরত পাঠিয়ে ফেরত পাঠিয়ে
Item two.
Item number 2, I am for the petitioner.
Not the statement.
This has been for extension of interim order, but I am at fault today because there was two folds of direction upon me. One, payment of deficit court fee that I have paid, and another, I was not asked to use a supplementary affidavit. Supplementary affidavit is not ready, but that is yet to be affirmed. But the interim order that has expired on 3rd of July.
My lord, I am strongly opposing the extension of interim.
So, my lord,
Yeah, my lords.
A liberty was given to the state to use affidavit. That affidavit has not yet been used by them.
That has been used.
No.
My lord, because no, that has not been need my lord, needed, my lord, because the interim order has been passed by my lord, just my lord, Hiranbhai Bhattacharya. My lord, on the basis of the alternative might stop. They are, it is admitted fact, they are the, my lord, the authorized occupant of government land. And the order has been passed by the my lord SDO. There was the assurance that they will be provided an alternative shop, my lord. My lord, after passing of this order, alternate shop has been allotted to them, and they have refused to accept, my lord. And it is explicitly clear from the order, my
Why
lord.
haven't you filed your affidavit in opposition? I could have taken up the matter.
But let
My
me take
kind
that
director,
instruction
sir,
from
my
my client.
report in the form of affidavit.
For a limited period, file your affidavit in opposition in the meantime. I
It
take
is
up the
my
matter.
kind director has to file my report in the form of affidavit. It is short matter. We have already allotted the plot.
So you want to come back with a report in the form of
Yes,
affidavit?
my lord. The report is with me, my lord.
In the mean,
I prima facie file.
for 7 days, kindly extend this for 7 days. In the meantime, let them come. If that's the fact, my lord, I shall not praise this matter.
My lord, from the
If
order,
it's
it is,
sufficient.
my lord, clear that if the alternative plot is allotted,
Yes, yes,
then,
yes.
my lord, the order will be my lord, automatically vacated, my lord. Can you see, my lord, the order? My lord,
Let
page
them
3
show a
of the order.
document that that was.
Yes. That has been allotted. My lord. I have received the, my lord, report, my lord. The plot has been allotted. Can you see, my lord? My lord, can you see page, my lord, 7, my lord? Page 7 of my report. My lord. This is the order passed by the sub-divisional magistrate.
Is instructed to allot.
Yes, Lord. Thereafter, my lord, kindly see, my lord, page, my lord, 10. Pursuant to this order and pursuant to the order passed by this honorable court, my lord, block development officer, my lord, inform them plot will be allotted, my lord, on 1st of June 2023 at 12:30 p.m. Name of all the petitioners appearing.
Oh, it's better, my lord. Kindly allow me to come back on Monday. I will show this document to my client. If that's the fact, there would be no occasion to move this
Therefore, we have
matter.
annexed all the my lord, photographs also we have annexed.
The order has been passed, whether that was communicated to my client or not, that's not.
Thereafter, they have submitted one representation, page 8, my lord.
Yes, after they were given an allotment, there is a representation. They say that this place is not fit
That
for
was of
business.
29th of May representation, and this allotment is of 1st of June.
29th May 2020.
And the allotment is of 1st of June.
No, prior
Page
to that,
10.
an order has been passed, my lord, 25th
10
of
is
May,
the 1st of June.
page 7, my lord, prior to that. Order has
Really, I will
been
look
passed on
page 10, my
25th of
lord,
May
that's the 1st of June.
2023, my lord.
The order is on 22nd May.
Yes, but the allotment that is at page 10, that is dated 1st of June, but kindly allow me to come back on Monday. Let me talk with my client. If that's the situation, well, I can't phrase this matter before Lordship. Because I can't go beyond the order, interim order has been passed in my favor. So let me take instruction and come back on Monday.
There is no need of extending the interim order, but my lord,
The next date,
yes, ma'am.
only till the next date.
Great. ma'am.
You'll take this back or
Yes.
it'll remain with the
I
next?
shall file a report in the form of affidavit.
Yes, please do.
আমি কপিটা দাও।
Learned
my
counsel
report
for
deals
the,
with
heard learned counsels for the parties.
Yes,
Paragraph, learned counsel for the state respondents seeks to submit a report in the form of an affidavit in this matter. Paragraph, let the matter appear under the same heading on 20th July,
20th, yes.
20th, 20. Paragraph, the interim order granted earlier is extended till the adjourned date.
Great. ma'am.
For the petitioner, let them show.
Item 3,
But item number 3, I appear for the alleged contempt, my lord. On the previous occasion, my lord, I have already filed my affidavit in compliance, stating that I have complied with the lordship's order. My lord, though they, my lord, alleges that there is no compliance at all. My lord,
I
this
find
matter
an
has
exception to that, my lord.
this matter has to be heard. Your lordship, my lord, because it will take some time, my lord. Your lordship may kindly fix this matter on the next week. Any dates? Dates?
Last time also time was.
My lord, no.
Kindly
Last
give a
time,
short
if your
date,
lordship
my lord.
kindly sees 2 dates, I
Kindly
don't want to
give a
say that
short date.
16th of May and 15th of June, both on these or those dates, adjournment was granted on my learned friends.
Mr. Siddiqui is prepared. 2 dates also is mentioned.
Kindly give a short date because the 9th
short
of
date,
March order
short-
we are waiting.
short-
And they filed a review, Lordship.
short-
Remember, they filed a review. Review was
That
dismissed.
was dismissed.
That was dismissed.
1st August.
So the ground
First order.
First, I'll come back. I'm extremely grateful.
I'm letting Mr. Somo Majumdar in this.
On prayer of the alleged contemnor, the matter is adjourned. Let the matter appear under the same heading on first
You
order.
order the case, so. First. চলে এসছে। First.
Item 4.
But I appear for the alleged contemnor in this matter. In this matter, we have already filed an affidavit of compliance and we have complied with your lordship.
Yes. Complied? Have you seen that? Complied? Yes.
So it has been complied.
It appears from the affidavit of compliance and is also submitted on behalf of the applicant that the order under contempt has been complied with. Paragraph in view of the contempt.
My lord, I stand corrected, my lord, but I had filed the compliance but not affidavit of compliance.
Only compliance, but no file affidavit of
Then I'll come back with an affidavit of compliance. Lordship kindly, no, because that will be a wrong submission by part.
Learned
sorry.
counsel for the alleged contemnor seeks to submit an affidavit of compliance in this matter. Paragraph, let the matter appear under the same heading on next week, since it has been complied with. 19th July.
19 July. Yes.
19th.
July.
My lord, no review till date in
Item
the next
5.
matter. Lordship would kindly issue a rule of court.
I say that the matter maybe the original brief, my lord, is lowered down as because my lord to the department to get the certified copy, my lord. My lord, up till now, my lord, they did not give me hand over the certified copy. Only for this reason, my lord, I could not file the review. So, my lord, I pray a short date, my lord.
My lord, 16, my lord, kindly
Yes,
see
my
the
lord.
dates. It has started from 13th
Yes, my
March,
lord.
23rd March, 18th April, 16th June, 13th July.
Yes, my lord.
But kindly issue the rule of contempt, my lord, let them come. Kindly. But this.
Fine.
Hey, now.
Rule be issued. Several adjournments have been sought by the learned counsel for the alleged contemnor seeks further accommodation. Paragraph, it appears from the record that several adjournments were granted to the alleged contemnor.
My lord, 3.
Yes,
Respondent number 3 is the contempt.
on his prayer that he seeks to file a review application against the order under contempt. Stop. No such review application has been filed till date, despite being afforded several opportunities. Paragraph. The order under contempt has also not been complied with. Paragraph, in view of the above, comma, issue rule. Returnable date. 27 July.
27.
The rule is made returnable on 27 July.
But my affidavit of service may be kept.
He is on record.
It has been served. Personally, Lordship had directed me to serve them personally. I have done.
Affidavit of service should be returnable on 27 July. Item 6.
Lordship, I am for the petitioner. Your lordship kindly see last occasion, contemnor submitted that they will transfer to other place. Your lordship, I seek for add the new officer who take charge of the file.
You filed an application to that effect?
No, my lord, your lordship, my prayer is recorded, but I inquired and office communicated that one Tapos Kumar Sardar took charge of the file.
See, for further compliance of the order, Lordship, the matter has been remitted to the criminal court, Lordship. This is the.
Where is
Lordship,
the?
I am not. Lordship, I am not appearing. Lordship, they have not served. I am not appearing. I am
No, no, no,
appearing for
they
the original.
Added. Yes,
Yes, that's
your
why I
lordship
said.
directed me to add. I inquired and thereafter came to know one Tapos Kumar Sardar is in charge of the file.
Yes, Lordship,
But
and the matter has been remitted to the criminal court. Lordship, the case
That
has
is-
been filed and the date has been.
yesterday, my client went to the criminal court, no case has been.
Lordship, the details are there.
Come back with an affidavit in that case.
Lordship, I am the original alleged contemner who has complied with his part of the order.
Let them file an affidavit. My
So-
lord,
Lordship, I have already filed.
So
Lordship,
please do not make submissions on behalf of
My-
the other contender who is being added now.
Lordship, I have only gathered information that it has been complied. It has been remitted to the criminal court. Lordship, it is my
You
duty
can
to
come
just
back with an
inform.
affidavit, fine, otherwise I will not accept this submission.
Lordship, on whose behalf?
my lord, I am adding, your lordship can kindly give to you. And I am serving a copy.
On prayer of the applicant petitioner, liberty is granted to add the present Deputy Labor Commissioner within bracket P. ELMW section.
My lord, now Deputy Labor Commissioner P provision, on promotion, but actually designation is Assistant Labor Commissioner. That is a promotional post.
So please give the entire
Madam.
nomenclature. Wait, Jita, add the. To add so and so as contender number. Should be two.
Yes, yes.
Contender number 2 in the contempt application. Paragraph, the petitioner is directed to serve copy of the contempt application along with annexure thereto upon the added alleged contender and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on 2nd August. Should be sufficient to serve. Seven.
Petition. Six and seven.
No, 7 amount.
Yes, 7.
7, Lordship, kindly come in and phase 2 of the.
It's appearing for the first time. You to serve and come back.
Lordship, my learned senior friend is appearing. If your Lordship does.
Contempt application you to serve. Officially to serve. Upon the alleged contempt.
Lordship.
The applicant petitioner is directed to serve copy of the contempt application along with annexure thereto. Join to. Miss Cochin. Along with annexure thereto. Upon the alleged contender and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on 7th August.
Great.
Actually, I am tendering my unconditional apology. Well, on the last occasion, when my lord heard this matter, and my lord, I did not appear, I have to take the responsibility. I cannot blame to my junior. But my lord, before that, everything has been complied. Before that,
No.
Kindly-
I have. to
kindly
file
see,
an
this is the
affidavit.
affidavit.
I have to file an affidavit. My lord,
দাঁড়ান না জজ সাহেবকে আগে এটা দেখাতে দিন my lord, here the contempt, my lord, because it was, my lord,
The show cause that was issued. upon
well,
the-
this is the show cause, my lord. Kindly see.
This is not the show cause, this is a report. in
Report
the
of-
form an
Report, my lord. That's why, my lord, I am tendering unconditional apology before that date.
So you are no one to tender unconditional apology.
Yes, my lord.
Your contender should
All-
file a show cause or I'll issue rule.
Well, a contempt is here. My lord, I have told her,
So no
you-
show cause is filed, I have to issue rule today.
my lord, kindly take that, my lord's discretion. My lord, it is my lord discretion, my lord, but it has been complied. It has been
Comply with.
compliance. This is compliance. Kindly see. I will submit. I need
This
not
is
go.
compliance of what?
Compliance of my lord's sort.
Where is the show cause?
Show cause. I will submit. I will submit a show cause.
Not
the
today. Let him come back tomorrow.
Well, come back, my lord.
Not today.
Not today.
Tomorrow, if the show cause doesn't come, rule will be issued. You need not.
Well, show cause, my lord,
By the condemner.
yes, so,
As to why she was not found present in court.
because it is my fault. It was my fault. That's why, my lord, because they,
Choose to find the show cause file, you can do that. What is this, Mr. Singh?
I will come. My lord, instead of tomorrow, my lord, is it possible? Monday, my lord?
No, tomorrow.
Tomorrow.
We should tomorrow otherwise, yes.
All right, my lord, tomorrow.
It's not complied.
But yes, my lord, I will come with you. My lord, at this,
No mercy.
my lord, at this, no, I know my lord's view. My lord is very strict. I should say this is, my lord, the affidavit of dated, my lord, kindly record.
Not today, affidavit to Fero Didin,
Affidavit.
My lord, item 9 and 10, I am playing not today on behalf of Mr. Amit Pan. He is engaged in court number 42.
I am nine, my lord, I am 46.
Complied.
No, my lord, I review my.
File.
Yes, my lord, and copies are. My lord.
Not today only on behalf of Mr. Amit
You
Pan.
spend it by not today.
Mr. Amit Pan is appearing in this matter, my lord. I am not, as per instruction of his clerk.
Review is pending, so please come back after some time.
After some time.
The review is in.
No,
here.
lord,
What?
it's up.
NLP time.
I'll fix a date because
Yes,
review
madam.
has to be heard. On prayer of the applicant petitioner, the matter is adjourned. Let the matter appear under the same heading on 3rd August.
3rd August.
Review application to issue. Review to actually, but they couldn't. It will be taken up together.
Yes, madam.
Item 11.
May I please your lordship? I beg to appear on behalf of the petitioner.
Is it appearing for the first time?
My lord, this matter is having a checkered history, my lord. May I humbly submit, my lord? After filing this contempt application, I was informed that this order has already complied.
Okay.
Thereafter, my lord, the private respondent has preferred an appeal. Subsequently, appeal was not pressed. Kindly, order to the now, in present situation, my lord, the BL, may I humbly say, the order was to demarcate the government land and demolish the unauthorized construction therein. Demarcation was complied and private respondent has demolished their own unauthorized construction. The order was therefore complied. Now, the BLLRO has issued a notice at page 34, my lord, annexure P3. Kindly comes, my lord.
Of the contempt application?
Yes, of the contempt application.
Yes.
Here, it was stated, my lord, in compliance of the solemn order of the Honorable High Court in WPS such and such, read with section 133 of the Code of Criminal Procedure, being SDM case number such and such, for demarcation work will be held on 16th July 2023 at 12 p.m. at plot number, jail number 22, plot number 2591/5171, within bracket respondent's area. This notice doesn't have any utility in present situation, and 2591/5171 is my plot. My lord, kindly comes to my lord's order at page 25, annexure P1. Kindly comes page 26, my lord. Second paragraph. May I read, my lord?
Yeah, I've gone through.
Oh.
The 19th March order was directed to be complied with, isn't it?
Pardon, my lord?
The 19th March order of the
it
was
is-
directed to be
Yes,
complied with.
already order has complied, and last night I have received a notice from the Krishnanagar Police District Kindly এটা একটু দেবেন দর্শক। May I read the second paragraph, my lord? In compliance of the order number 13 dated 10/5/2023 of the Honorable High Court, Calcutta, in WPA number 3989/2022, as depicted in the petition, OC Dhubulia communicated with the BL and LRO Krishnagar 2 block, and as per schedule on 16 June, he, along with accompanying officer and force of Dhubulia PS, KPD BL LRO block in presence of Executive Magistrate, Shodor Subdivision, Nodia, had been at Noapara Colony under Dhubulia PS, where the BL and LRO demarcate the vested land in presence of the petitioner, as well as the private respondents and local inhabitants. Then on 19 June was fixed for removal of illegal encroachment. Accordingly, Dhubulia PS informed the OP, namely Khairul Shah and Atikul Shah, regarding demolition program, and also directed them to remove their illegal construction in the demarcate vested land in question within this period. On 19 June 2023, the officer and the force Dhubulia Krishna 2 had been spot the Dhubulia PS GT number such and such, that the found that the land in question is vacant, and all the construction have been removed. After the field inquiry, BL in LRO Krishnagar 2 also sent a report through email, memo number such and such, and a copy of the such annexed herewith. Local people were present at the time. Yes.
So why do you still want to carry on with the contempt application?
I am not carrying on. I am just now praying that to kindly set aside this notice. They are going, why they are going to demarcate my land? 25915171 is my land, and within bracket respondents area, it doesn't make any sense, my lord. The notice in present situation, the notice doesn't have any utility also.
Where do they say that they will demarcate your land?
Sorry,
Where do they say that they'll demarcate your land?
I'm coming, my lord.
This is only a compliance that they have done it already.
Yes, already they have complied.
So there is
But-
not the demarcation notice.
But kindly see the notice at page 34, my lord.
This is an earlier notice.
Yes, earlier notice, but demarcation will be conducted on 16 July, my lord.
So this is a fresh cause of action in that case. In the contempt application, nothing can be done.
My lord, it is, if this notice was served before filing the contempt application.
This notice was not part of your writ petition.
Yes, it is my part of the writ petition. During the pendency of the writ petition, similar notice has been issued, and my lord was pleased to set aside said notice also. My lord, kindly see the page 36.
When was the order of the writ petition passed? It was passed on 10th May 2023.
Past order was page 36, my lord.
The final order.
Final order 10th.
Come up against the final
Yes,
order.
yes.
That's 10th May.
Yes,
This notice was issued on 9th June.
yes.
So how does it become part of your writ petition?
After disposing the writ petition, they directed that my lord has ordered to demarcate my land. Kindly see the demarcation of the land, plot number 25915171.
This is a separate cause of action altogether. This
Right.
cannot be part of the contempt application.
It's a malified interpretation of your my lord's order, my lord. Humbly,
That's a separate cause of action. If you're not happy, you can come up before the
It's-
appropriate forum.
they have stated that in connection with the case number, the writ
The
petition. my-
contempt application deals with order dated 10th May
Yes,
2023.
yes,
nothing
yes,
beyond that.
yes,
So, and you say that that order has been complied with.
yes.
So therefore, nothing further remains in the contempt application.
I am not denying that, my lord. But this
What you
notice,
point out is a separate cause of action.
This
Cannot be dealt
notice-
with in a contempt application.
but they are saying that they in compliance with my lord's order. My lord, kindly.
So that is a separate cause of action. Cannot be dealt with in contempt. You can take this. Take it to the- Learned counsel for the applicant petitioner candidly submits that the order under contempt has already been complied with, and he does not intend to proceed with the contempt application any further. Paragraph in view of the same, comma, the contempt application being recipient's assistance is disposed of urgent certified website copy.
Deeply obliged.
That's a simple process.
Deeply.
नाम तो दिया मैंने
Next. Item 12.
This is restoration application.
Have you served the?
My lord, notice in respect of restoration application and the condition delay has been served upon the learned state advocates, Mr. Shishana Bandhavadhyay. My lord, kindly direct the petitioner, serve the copy of the writ petition again.
Today it is only restoration.
Restoration.
You have no objection?
No.
Restored?
My kindly restored. Writ petition was dismissed, my lord, on 3rd January.
Writ petition, you don't have a copy? Because you wanted to
Already,
submit it.
I shall serve them, I shall. serve them.
already submitted before GP.
I shall serve them, sir. Don't worry.
You wanted to come back with a report in the form of affidavit.
My lord, as you,
Let's see.
as your lordship directs,
There is already a direction.
already direction.
So please take a note of it and come back with your report on the next occasion.
My lord, I will come.
Can. One of 2023. Service level. Third learned counsels for the parties. Comma, good grounds being shown. Learned counsels for the parties stop. Paragraph kuru. Good grounds being shown, comma, the delay in filing the restoration application is condoned. Paragraph can 1 of 2023 is disposed of disposed of.
I am grateful.
Paragraph can 2 of 2023. This is an application for restoration of the writ petition, which was dismissed by an order passed, dismissed for default by an order passed on 3rd January 2023. Paragraph, sufficient grounds being made out, comma, the application is allowed. Paragraph, sufficient grounds are heard learned counsels for the parties. Paragraph, sufficient grounds being made out, the application is allowed. Paragraph, the order passed on 3rd January 2023 is set aside. Paragraph, the writ petition is restored to its original file and number. Can 2 of 2023 is disposed of. Paragraph, WPA the order. Let the matter appear under the heading motion on 14th August.
My lord, I am.
Please prepare your affidavit, your report in the meantime.
I am grateful.
Chain. My lord, I am appearing on behalf of the proposed added respondent, my lord. My lord, may I file my affidavit in reply?
My lord, Mr. Udanan Vedal appearing on the petitioner, my lord, this matter is going on in my lord, the code number 5. Kindly, my lord, fix the matter on Monday, my lord, otherwise my lord will not come to continue.
Yes.
My lord, his matter is going on in my lord, the code number 5. He
Yes.
is unable to come before your lordship.
So come back some other day.
My lord, it is
Our
my
applications,
application
my
for
lord,
addition
including
of
the
party.
additional parties,
My-
including lordship, the one can for my part, lordship, that is for vacating of interim order, lordship. We are suffering a lot, lordship, for this interim order, my lord.
My-
Kindly, if your lordship, kindly take this matter tomorrow, lordship.
No, not possible.
My lord, only one thing, my lord,
Kindly fix
before
the
your
file.
lordship thinks of
My lord,
fixing a
Monday,
date.
my lord.
Just a minute. My lord, there is one German point, my lord, which is subject to your lordship's decision whether this actually calls for my being added as a party. The reason is, my lord, they have preferred a rate. They have preferred a rate and they have actually relied on various documents citing that they are still paying the rent of a portion of land that is Kapsaria Stockyard. My lord, we have nothing to do with that. Because it fell from your lordship that how is it that you want to be added as a party? The reason is, my lord, taking benefit of this order, repeated criminal cases are being instituted against my employees, one. Second is, my lord, the area which is just ahead, because between National Highway and my lord Kapsaria Stockyard, there is around 150, 145 meter of lands, my lord. This is something which has been acquired in favor of National Highway Authorities of India. And my lord, during the tender, when they had called for the tender, it was a part of the tender terms and conditions. tender terms and conditions provided that this is the area which you have to cover during your contract tenure, because that maintenance is on us. We have to maintain the highway. And my lord, to do that, we need to set up the hot mix plant, my lord, and other such accessories and plants and machineries to ensure, my lord, that the road is maintained in proper form. Now, my lord, this 150 meter, which they have encroached in the guise of this rate, my lord, but this is the one which is our concern, because there, my lord, the hot mix plant was there. Now, my lord, it was basically one of the case that this is, you have the entire stretch left. My lord, if your lordship kindly sees the practical difficulty.
Since the petitioner is not there today, come back on some other day.
My lord, then may we come back on Tuesday? My lord, and relatively in the top, because my lord, what difficulty,
We are
the
suffering.
rain
my
has
lord.
come.
Order is still 31st. Come back on 25th.
My lord, give us some late because lordship, because these canned applications. Lordship, today is supposed to lordship heard this award vacating of interim order, lordship.
Interim order is still 31st.
Very well, my lord.
My
I
lord.
shall come.
Then, my lord.
We don't want to
I'm not
go
extending
against. I understand, my lord, your lordship's diary is absolutely tight, my lord, but we really wanted to take some benefit,
Sometimes,
because
lordship,
why I tell, my lord, our anxiety, my lord, may I just say another two statements, my lord, before I conclude. My lord, I am basically bound by a contract which has certain layouts of terms and conditions, which configures that these are the standards of the highway rules and regulation which I have to maintain. Now, my lord, the rainy season has started. The pits and all other the damages which are being happening there, my lord, this is something which is becoming unmanageable for me. The reason is, my lord, the entire system is based on this, for this limited stretch of land, this much of kilometers, this machine, this particular, because if we get this done somewhere else and bring it, by the time we bring it, it will solidify at least semi-solidification. So this is going to deteriorate the condition of the work. So these things are there, my lord.
On pair of the petitioner, the matter is adjourned. Let the matter appear under the same day on
25th July.
Be ready on the next occasion.
Much obliged, your lordship. My lord, the affidavit, your lordship has noted.
Service.
Affidavit in reply, my lord, we have filed in court, may be taken on.
The affidavit in reply submitted on behalf of the proposed added respondent is taken on the call.
In connection with CAN 1, my lord.
This is an affidavit in reply.
Yes, my lord, affidavit in reply. My lord, because this is not the writ. I don't know the application.
Yes, but you have to state that it's a, no, I have the affidavit in reply.
Affidavit in reply. My lord, because this is related to only CAN 1.
CAN 1 and extra. So CAN 1 is good. Affidavit in reply.
आगे take to my lord, both these application, my lord, heard together, my lord, both.
Proposed added respondent in CAN 1.
Yes, my lord, because we do not have an access to the writ at present. Much obliged, your lordship.
Petitioner.
And we have also served, my lord. Much obliged. 14.
I appear for the KMD in this matter.
Petitioner.
His.
Mr. Gautam is appeal.
I'm for the split.
Affidavits are exchanged in this.
No, no. Nothing has been.
There was a direction for affidavits. Is it necessary?
If
Earlier, I find there was a direction for affidavits.
affidavits. was directed-
Order passed on 16th March 2020.
2015.
There was a direction for affidavits.
No, affidavits were not filed. Affidavits,
After change of the mallet.
Mr. Talukar, affidavits are required.
at least report from the state is required because the entire land has been acquired, my lord. in two phases. In two phases, the land was acquired. So state's report is very much necessary.
And the
When-
petitioner's case is that land was not acquired.
হ্যাঁ, এফিডেভিট এখনো আমরা তো পাইনি,
Affidavit দেয়া হয়নি তাই পাননি।
Affidavit file হয়নি এখনো।
না করিনি অনেকদিন 16 মার্চের পর থেকে কোনোদিনও
What he
2018
says, Lordship kindly, this is the beyond the scope. In fact, he was agreed by the compensation awarded. The remedy was otherwise. He could have applied for reference, which he admittedly not done. So this is now the read court cannot extend its said.
Why don't we hear the petitioner? আপনি খুব
Paragraph-
ছোট করে বলুন আপনি কি চাইছেন?
আমরা আবার যে টাকাটা দিয়েছিল তার থেকে যেটা দেওয়া উচিত এখন 2013 পরে ফেয়ার কম্পেনসেশনে, সেই টাকাটা আমরা এখনো পাইনি।
আপনি আগের টাকাটা কবে পেয়েছেন?
সেটা 2014।
It was prior to 1150.
No, Lordship, there was earlier writ petition. If you Lordship sees few paragraphs I am referring to. Paragraph 9, Lordship kindly come. There was a earlier writ petition moved by the petitioner. And for alleging non-compliance, a contempt application was moved. At paragraph 10, Lordship will find. Then during the pendency of the contempt.
This is for determination of share of the petitioner.
Yes. During the pendency of the contempt application, checks were produced and they were received by the petitioner. Paragraph 11, he states, there was a joint inspection. So he was not satisfied with the compensation awarded. Lordship, kindly come to the documents at page 25. This is about acquisition, the information. Next, Lordship, kindly turn to
1894 Act.
1894. Lordship, kindly come to, no, 1948 Act. 48 Act. 20 space 27. Lordship, kindly the copies of the copy of the award. Annexed. Then one more document, Lordship, kindly come to page 44. He is not denying this. This is the letter written by the petitioner. Sixth line, Lordship will find the name of Srimati Shobha Das was listed in the award list. He is not denying that. And a contempt application was moved, Lordship will find page 49. Yeah, 49 and the petition. Oh, yeah, page 50 is the order, relevant order. Lordship, kindly turn to page 50. '50 and 51, the photocopies of the checks. Then a joint
He is primarily aggrieved by the award granted.
award. So his remedy was otherwise for seeking reference. Pursuant to that, my lord, a joint inspection was also, my lord, carried, my lord, at page 52, Lordship will find.
Because he is moving in person, let us hear him. আপনি অ্যাওয়ার্ডটার অ্যামাউন্টটা বাড়ানোর জন্য অ্যাপ্লিকেশন করেছেন এনহ্যান্সমেন্টের জন্য। আপনি কি অথরিটির কাছে কোনো অ্যাপ্লিকেশন করেছেন?
অথরিটি একটা চিঠি দিয়েছিল পেজ 42 তে দেখুন, বলে ফ্রেশ অ্যাপ্লিকেশন করে জমা করতে হবে।
This is not that.
এটা তো 2015 আপনি অ্যাওয়ার্ডের চেকটা কবে পেয়েছেন?
অ্যাওয়ার্ডের চেকটা পেয়েছি 2016।
চেক পেয়ে আপনি খুশি নন, তাই তো? ওই অ্যামাউন্টটাই আপনি ডিসপিউট করছেন। 2016 পরে আপনি অথরিটিকে কোনো চিঠি দিয়ে জানিয়েছেন? যে আপনি এর থেকে বেশি অ্যাওয়ার্ড চাইছেন?
হ্যাঁ, ওই কন্টেম অফ করলাম, এই দেখি
কন্টেম্প করার পরেই তো চেক দিল আপনাকে, তারপরে আর কিছু করেননি তো?
তারপরে কোনো কিছু করেছেন?
50 পাতায় দেখুন কন্টেম্পটের অর্ডার। এরপরে কিছু করেছেন কিনা সেটা জজ সাহেব জানতে চেয়েছে।
আপনার আগের মামলাটা ছিল আপনি কম্পেনসেশন পাচ্ছিলেন না বলে,
হ্যাঁ।
তারপর আপনাকে কম্পেনসেশন দেওয়া হলো।
হ্যাঁ।
আপনি বলছেন আপনাকে অ্যাডিকুয়েট কম্পেনসেশন
না,
দেওয়া হয়নি,
adequate, হ্যাঁ।
টাকাটা আরো বেশি হওয়া
হ্যাঁ।
দরকার। কন্টেম্প অ্যাপ্লিকেশন যখন চলছিল তখন আপনাকে চেক গুলো দেওয়া হলো,
হ্যাঁ।
তারপরে আপনি কোনো স্টেপ নিয়েছেন?
যেটা চেকটা পেয়েছি WP 29,442-এ, আর তারপরে আমরা ওই 16,325 এটা রিটটা করলাম।
হ্যাঁ, এর মাঝখানে অথরিটিকে কোনো চিঠি দিয়ে জানিয়েছেন যে আপনারা টাকাটা আর রিকনসিডার করুন, এই টাকাটা সাফিসিয়েন্ট অ্যাডিকুয়েট নয়, এরকম কোনো অ্যাপ্লিকেশন আপনি করেছেন? কারণ আইনত একটা অ্যাপ্লিকেশন করা দরকার ছিল আপনার।
আচ্ছা,
It was not done. No averment is in the writ petition, no document has been.
No, there is nothing actually.
I didn't find. Everything is before 16.
টাকাটা
হ্যাঁ,
পাওয়ার পরে
40
আপনি ডাইরেক্টলি কোর্টের কাছে রিপিটিশন করে বললেন যে সাফিসিয়েন্ট অ্যামাউন্ট দেওয়া হয়নি।
হ্যাঁ, হ্যাঁ। না, আমি 41 দেখুন পেজে, ওতে আমরা ওদের কাছে চেয়েছিলাম আর ডিটেলসটা দিয়ে ওরা দিয়েছে।
এগুলো সব আপনার আগে রিপিটিশনের অর্ডারের আগে,
আচ্ছা,
তাই তো?
রিট পিটিশনের আগে।
কারণ এখানে আপনি কম্পেনসেশন চাইছেন, কম্পেনসেশন আপনাকে দেওয়া হলো, আপনার এই রিপিটিশন আপনি কম্পেনসেশন চাইছেন না, আপনি টাকাটা বাড়ানোর কথা
বাড়ানোর কথা,
এনহ্যান্সমেন্ট চাইছেন,
এনহান্সমেন্ট,
তাই তো?
হ্যাঁ,
কিন্তু
ফেয়ার কম্পেনসেশন।
ফেয়ার কম্পেনসেশন চাইছে, কিন্তু সেটার জন্য আপনি কোনো অ্যাপ্লিকেশন করেছিলেন অথরিটির কাছে? আপনি যে স্যাটিসফাইড নন সেটা তো অথরিটি জানলোই না,
আচ্ছা,
তাই তো?
হ্যাঁ। না, আর আমি যে রিড করলাম, রিটের কপি তো ওদের পাঠালাম, তাহলে
আগে জিজ্ঞেস করছি।
আচ্ছা,
এটা তো কোর্টে হয়ে গেল।
হ্যাঁ।
কোর্টে যুদ্ধে আসার আগে আপনি কি অথরিটিকে কোনো চিঠি দিয়ে জানিয়েছিলেন?
না,
affidavit in opposition will not really improve the case.
Improve this. This can't be
Yes,
entertained.
Mr. Bandyopadhyay, what you suggest?
His prayer is for seeking a direction for payment of enhanced compensation.
He is aggrieved with the amount. He is asking for enhancement. So he has not applied, let him file an application.
That cannot be, perhaps cannot be. Section 18 does not permit. There is no provision for applying section 5.
Yes, yes. But why, if you can consider during the delay.
6 weeks was open to him. No, 6 weeks. And 6 months.
We are in 23.
And section 5 cannot be applied so that
Unnecessarily affidavit. in
unnecessary.
opposition, reply.
This can't be. And his prayer is also for seeking a direction for directing the respondents to give enhanced amount. Where is the enhanced amount? Prayer is also misconceived. When the law does not permit, my lord, the court cannot extend it.
Yeah.
Yes. Had there been any such scope, lordship would have. একটা 16 পরে একটা অ্যাপ্লিকেশন করা থাকলে আপনার ডিরেকশন। দ্যাটস দ্য ডিফিকাল্ট। আগে তো আপনার অ্যাডভোকেট ছিল, তো অ্যাডভোকেট ফাইল করেছিল। ফাইল থ্রু অ্যান অ্যাডভোকেট। The position is settled. My lord knows that in section 18.
I would like to show him section 18. Land Acquisition Act টা দেখুন তো একটু আছে কিনা।
এটা অ্যাপ্লাই করছে।
এটা নয়, এটা নয়।
আমাদের বইটা আনো না, আমাদের বইটা আনো না। ল্যান্ড একুইজিশন অ্যাক্ট নিষেধ কোথায়? ব্যাগটা এখানে। তোমাদের গ্যালারিতে নেই কারো কাছে? ব্যাপারটা এই হয়েছে না, সেটা করলেও that case has also not been made out. The 13th case has also not. Question of 13 does not come. Initiation award was passed that under Act 2, and that case is. Unfortunately, he is remediless.
That I'm finding it difficult to accept actually. আপনি দেখেছেন সেকশন 18 টা দেখেছেন?
No, he is having 2013 Act.
2013 Act.
2013 Act, this is not the case.
Provision আপনি ইন্ডিকেট করছেন।
It was 20.
Section 18.
Stands in his way. That cannot be also. And there is no pleading also in the writ petition about 2013. 18th of it.
Section 24 into 9 টা দেখুন। Section 24 to 9.
Of 2013 Act or Act 1? কোনটা কোন বইয়ের? আপনার বই বোধ এক নয়, কিন্তু আপনার এটা আর এটা এক নয়।
Section 24 নতুন আইন এটা।
24 of the 2013 Act.
23, he is referring to 2013 Act. 24 subsection 9 he is referring to. এটা দেখাচ্ছেন এটা? 24/9 24/9 কোথায়?
Right to fair compensation.
নতুন বলছেন?
এই তো 24 24/2 perhaps he is trying to refer. এই তো 24/2. 24. আমাদের বইগুলো কোথায়?
ওখানে নেই। কিন্তু ওইভাবে আলাদা করে রাখি গ্রুপ 7 আর সব গন্ডগোল করে।
কারো কাছে আপনার বইটি একটু জজ সাহেবকে দিন।
2013 Act. When it is necessary, it's not found.
Thank you. Thank you.
Section 24.
20 is referring to section 24.
Please help him if you can.
Section 24 plus the date of award is important. As if from the submission of is saying this he has received in 2016.
16, yes.
So the 24 clarifies it has to be a specific time when this award was declared. If the state can say on that which day the award was declared, then we can read section 24 and he can get the benefit of that. Because it's undoubted that he has filed a writ petition in the instant, and after that the payment has been made in 2016. So when was it award made? That is important. If the award is made after 1st January 2014, is eligible for the new act.
15, is it?
14, your lordship. In National Highway is 15, but other act is 14. 1st January 2014.
That cannot be taken into consideration in view of subsection 2 of section 20. This act doesn't apply in this case.
The award
Proceeding has to be initiated under Act 1. It was initiated and concluded under Act
48 Act.
48.
But kindly see section 24A, where no award under section 11 is the first clause, and B says where an award under section 11 has been made, then such provision shall continue under the provision of the. So when was an award made? In his, the payment is only a payment receipt, your lordship. Definitely the authority has made an award. So the date of, if they can submit before lordship when this award was made, then we can conclude this part. From 2016 they have paid after around the first litigation, but they are not clear when this award was made, because section 24 specifies the time as well. If it was made 5 years back and in nothing, possession has not been taken, this is an entitlement. So that part has to be ascertained by the state, that when this award was made.
This is beyond the scope. Section 24 specifies certain contingencies. Here, nothing of that sort. That whether award was made, but compensation was not paid. Such a situation. Here, this is not the case. He was not satisfied with the compensation amount. He want enhance.
So let the affidavit come as directed, because there is a direction for affidavits already.
That is not in place.
Let that come.
If he wants to satisfy the.
আপনার যদি মনে হয় নিজের মামলা করতে অসুবিধে হচ্ছে বা আপনার বুঝতে অসুবিধে হচ্ছে, আপনি কোনো উকিল বাবু সাহায্য নিতে পারেন।
ঠিক।
Mr. Bandyopadhyay, please come back with a short affidavit.
I'm at the school.
The counsel for the state respondents seeks extension of time to use the affidavit in opposition as called for. Paragraph affidavit in opposition be filed within 2 weeks.
Let it be 4 weeks. So 4 weeks. Let it.
Not 4 weeks. Within 3 weeks from date. Stop affidavit and reply, comma, if any comma be filed within.
We are.
Mr. Das, affidavit in opposition copy পাওয়ার 1 সপ্তাহের মধ্যে আপনি রিপ্লাই ফাইল করবেন, আর একটু বেশি সময় লাগবে আপনার?
না, 1 সপ্তাহ।
Within 1 week thereafter. Paragraph, let the matter. Monthly list of August দিয়ে দিচ্ছি আমি, তার মধ্যে affidavit গুলো হয়ে যাবে।
I am not opposing for the sake of opposing, but to my understanding, my lord, absolutely there is no scope.
Let us not make a negative approach to a petition at the outset. Let us see what can come out of it. Monthly list of August. Huh? One year.
Monthly list, August. Hearing, may I report on it?
16. 16. I am for the petition, my lord. By the order dated 27th of June. My lord, your lordship was pleased to fix the matter of 19th. 27th June order, your lordship, 2 matters are there.
I beg to appear for the state, my lord. I'm led by Mr. Shubputin Dhar. We inquire about this matter was made returnable on today. However, the notice was served upon us intimating the matter was to be taken up on 19th.
19th.
But they informed that it was to be taken up on 19th.
Both the matter.
Regardless, my lord, we need some time to inquire the report.
There's another similar matter.
Yes, both the matter similar matter.
So will you come back on 19th with the report?
My lord, we shall come back on 19th.
Let it appear on 19th.
My lord.
By consent of the parties, let the matter appear under the same heading on 19th.
I'm grateful, my lord.
Thank you. আরেকটা matter আছে না?
Notice 19th লেখা ছিল, order 13th.
এটা আছে 13 জুলাই।
আপনার notice 19th লেখা।
17।
This is that matter, my lord. On the last occasion, my lord, a report was called for, my lord, and then it had fallen from my lord that the matter can be relegated to a civil suit which is pending, my lord. But so, my lord, I have a very small submission to make before my lord.
If you
Yeah.
confuse, Mr. Trivedi, the panel has changed and Mr. Sengupta is no longer appearing. I've
Well,
given
what
you
should,
a fresh service.
fresh service.
Notice.
I shall, my lord.
They are not in the panel any longer. None appears for the state respondents. Paragraph, since there has been a change of learned counsels in the state panel, comma, the petitioner is directed to serve fresh notice upon the office of the learned government leader and file affidavit of service on that agenda date.
I'm great.
Paragraph, let the matter appear under the same heading on 2nd August.
Yes, my lord. My lord.
18.
This matter, my lord, I was arguing, my lord, on behalf of the state.
In this matter, my lord, Mr. Amit Kumar Pan
Is appearing for the
appearing on
petition.
behalf of the petitioner. He is
My lord,
interested
I
in
am
court
not,
number.
now, my lord, the position is that I am not in the matter panel.
Yes.
But my lord,
Oh, you are
I have
not
been
in the
specially, I have been specially, my lord, engaged by the Lanet Ela
this matter?
to do this matter.
That's good. Yes.
So, my lord, just yesterday, I have got the letter from the Lanet Ela. There is a long gap. So, my lord, I am just praying your lordship to kindly let this.
Mr. Chatterjee?
Yeah, Mr. Chatterjee is there.
I am not in the panel, but I have instructions to appear for respondent number 2 and 3, my lord. I'll assist you, my lords.
Lord, the
Where are
inspection.
KMC, KMDA, yes.
All are here.
KMDA. Where is Mr. Talukdar? He's coming. What
My lord,
about
what-
KMC, Mr. Ghosh?
At this moment, my lord, Mr.
Actually, my lord, I am the answering respondent.
He's the answer.
But his presence is required.
True, my lord, true, my lord.
Be coming, my lord. Let me just continue with our bill. I'll call Mr. Ghosh ke paas jaake pass karo. KMC, madam. My lord, my land was taken away by some government.
Not there, I'm not hearing.
Oh, very well, my lord. Land was taken away, my lord. Inspection was conducted by at that time when the first time the inspection was conducted, my lord, the government authorities went, the officers from the office of the DM, so they said the report was filed, that the land was taken away, was utilized by the government and a road was constructed over the entire land. It was the first scenario. Later on, my lord, the KMDA was added. KMDA came before this court and said the inspection was not done in my presence. Another inspection was made. But the report is pending. We have not got the report as of yet. I don't know what's
Sir, I am ready with the report, my lord. Well, I'll place the report, my lord. Well, the report must be placed with a unqualified apology along with the report, my lord. Lord, what was alleged in the writ petition was a portion of petitioner's land is encroached by the KMDA or statutory authorities, my lord, and no compensation was given to the petition. My lord's pleasure was to direct the respondents. The district magistrate has filed a report before your lordship stating it is a fact that a portion, namely, my lord, 23 feet of the petitioner's land was encroached by the KMDA while construction of a road, my lord. At this juncture, my lord, the KMDA comes into picture after their addition, my lord. They file an affidavit stating, no, we haven't utilized the land. My lord's pleasure was again, my lord, they disputed that the petitioner's land was ever encroached, my lord. At this point, my lord, it must be mentioned before, my lords, that during the earlier inspection, the KMDA authorities were not there, my lord. The earlier inspection was done on the basis of the deed of the petitioner. Lord, at this juncture, your lordship was pleasure was on 31st of March to direct the ADMLR to cause an inquiry in presence of all the parties, including that of the petitioner. Now, my lord, this report before your lordship, my lord, is filed pursuant to such, my lord, inspection which was carried on in presence of all the parties, my lord. Lord, unfortunately, my lord, this time on inquiry on detailed survey, my lord, this survey was done in two very particular facts, my lord. Determining facts must be said before your lordship, my lord. The first thing is that it was done in the presence of KMDA and other authorities, which was not the case on the previous occasion. But secondly, my lord, it was done in accordance with comparing with the CS map, my lord, which was not done in the previous case. My lord. Unfortunately, my lord, this survey discloses there's no encroachment to petitioner's land. But his land is, my lord, CS plot number 1245, my lord. The inquiry and my report, my lord, states, my lord, we haven't, none of the authorities have encroached upon his land, my lord.
Have you received a copy of the
My lord,
report?
I haven't, my lord. I was very shy to give up the report, my lord, because there is a discrepancy. My lord, may I hand up to my learned friend?
May I add few
This
words?
inquiry was in your presence?
Yes. A joint inspection survey team was constituted. As per your lordship's direction, pursuant to our submission, that a joint survey be held in presence of all concerned, including the state authorities, KMDA, petitioners, and it was found that our contention was correct. What he is alleging, and another fact is, since 2014 and 15, the maintenance of the road has been handed over to the KMC. We are not maintaining that. That's one of the
Page
parts.
6 is the authorities and the petitioner were present, my lord. Page 6 of my report.
His land is 12,1245 and acquisition was 1246. Thank you.
Mhm.
What are your prayers?
Yes, please. Provide compensation, my lord.
The disposal of a representation.
My lord, what has happened? My lord, my land is not there anymore. Land has been converted into a road. Now, my lord, they come up saying that there is no road. So on fact, my lord, the acquisition was not done. Where my land starts from, the land prior to that, my lord, that was acquisition correctly.
The report says that no part of your land was used at all.
That
utilized
was
at all.
specifically dealt with at the time of inspection, that my land is, kindly see, when the inspection was first made, it was good, bad, indifferent, whatever they consult. They say, yes, my land was demarcated and there is a bitumen hot mix was spread about my land. That means my land was taken away. That was my case, my lord, that my land has not been acquisitioned properly and no compensation has been paid. They say the land has not been taken away, but the land has been utilized on ground. I prefer, my lord, what they are saying from their records, my lord, what I am saying is from my records. On ground, my lord, there is no, my land is not there. It has been converted into a road.
So how will the writ court still have?
Lord, I'll say, Lord, let a commissioner be appointed, special officer be appointed from this court. Lord, I doubt their findings.
Even
The
after,
special officer may be
Even
after the inspection.
This was done in your presence.
This was done. I had objected, my lord. I had objected that my land has been taken away. This is not, my land is not there. My lord, let them demarcate my land and give it to me if they are there. They have all the authorities. Let them demarcate my land and give it to me.
Private land. How can they?
My lord, how will my land has been utilized by the government and a hot mix between hot mix has been spread over my land. My lord, now they say that we have not taken away. But my lord, the government can only spread the bitumen hot mix. Nobody else.
It's a boundary dispute. It's a matter of evidence. This court cannot deal with
This court.
You know, which court will I go? Which court will I pray?
Civil court. Civil court is,
My land is not there. It has been utilized by them. Well, they are saying that we have not utilized.
Yes.
My lord, now
So is it a matter of evidence?
Lord, let a special officer be appointed and see whether my land has been actually utilized.
The same thing will happen.
Let them, I'll accept. I'll go to a civil court.
what he is now raising is a civil dispute.
You can. If you want to go through the, you've not.
Well, I need to go to the report anyways. I'll file an exception to
come
this.
back with an exception.
I'll file an exception to this.
Prima facie, I find that the writ court
And that
cannot
part,
follow
another aspect of the matter is, if you lordship kindly sees paragraph 3 and the paragraph 4 and 7, in 1982 to 2016, the petitioner did never inquired about his property. Even if someone has, someone, someone, no, this is
Government is taking taxes on a land which is not
we
there.
are, we are not saying that we have utilized that
Land
here.
is not, the land is not
Otherwise,
there.
how can you assert this? You're
sir.
right.
There is no verification of title when taxes are paid. You go and pay tax for the Victoria Memorial, they'll receive, they'll accept. That doesn't indicate that it's yours.
Milord, the land is recorded in my name, the land is
There
not.
will be verification of title when they receive
Milord, I
tax.
say this, Milord, the land has been, there is
Milord,
there is a existence of a land. Milord, they're taking, in their records also, there is a land. On ground, Milord, the land is not there. They're taking taxes on a thing, on a property which is not there. Milord, I cannot enjoy my property, I cannot see my property even. It's an open land. Nobody else, it's not a complaint that a private person has taken away my land. Milord, land is not.
He is seeking, he is
Land is
coming
there
before
on the
this
pen and
court.
paper, Milord, land
He
has
is
been taken
coming
away by
before
them.
this court with this rate petition seeking equitable relief.
Milord, from every aspect, Milord,
My lord, it's a
land is
settled
taken away
principle
by the
of law.
government, Milord, if a land is being taken away by the government and the government denies that I am not taking away the land, the government utilizes it, which court will I go to?
You have to show that the land is taken away by the
The
government.
land is not there. They
That
cannot
is
even
a
show that the
matter of
land is there.
evidence.
Making inspection, they have to show that the land.
Our case is not being denied. Only thing, this writ court cannot deal with this because it's oath versus oath.
Anyways, Milord, I need to come back with the
Yes, come
exception.
back, come
I'll
back.
come back with an exception. The one.
He does, this
Report in the
petitioner
form-
doesn't deserve the equitable relief.
Report.
Sir, Milord, I need a long time, Milord. I'll be consulting with some engineers, Milord, private engineers. I'll just consult with them once.
Very
There.
well, very well.
A month's time, maybe.
Month's time.
A month's time. Milord, I'll do a good. Client doesn't stay.
Yes.
A report in the form of an affidavit submitted on behalf of the third respondent is taken on record. Paragraph copy of the report is served, is made over to copy of the report is made over to learned counsel for the petitioner in court this day. Petitioners. Served and made over দুটোই লিখে দেবেন না। Served and made over দুটোই লিখে দেবেন। The petitioner seeks a month's paragraph. Petitioners seek a month's accommodation to use an exception to the report. Paragraph, let the matter appear under the same heading on.
Numberটা নেই।
16th August.
After sleeping over his right about more than 40 years, now he's seeking equitable relief.
True, but Milord, we must also ensure that no citizen is, Milord, we must rule out, Milord. Delay is there, Milord, but we must, we have to rule out that there
But it
is
is
prejudice.
also one who seeks equity, he must do equity. He has not done equity. He slept over his
That's
right.
Milord, I'll say what.
Very
That
grateful,
land
Milord.
was a vacant land. I have
Appear out
purchased.
on the next day.
I'm very grateful, Milord.
20.
I'm for the petition, Your Lordship. On the last occasion, there was a direction upon the state to submit a report in a form of affidavit.
You are
The-
appealing for the state?
The case of the petitioner is but the case of the petitioner is lordship, and the land is being acquired for the fencing of Indo-Bangladesh border. We received a notice initially from the BDO that we are acquiring your land for fencing of that portion. Then we received a notice from the concerned Jilla Parishad. But the case of the petition is that they are not acquiring it under 2013 Act. They have a land policy which is at page, which is initial was of 2014. Then in 2016 they have revised that policy. Now the petitioner case is that the petitioner will not give the land until it's acquired in 2013 Act. Why? Because in the state of West Bengal, one locality is called Devchai, Your Lordship. For coal mining, that land is being acquired by the state government. There, they have produced a list of compensation, whatever there, that doesn't fit their 2016 policy. So the petitioner case is that you cannot discriminate that. 2013 Act came into force on 1st Day 2014. Till today, the state government has not faced the rules for that. They have not framed the rules. Apart from all the states, the rules are there, but in our state, they don't have rules. The Act says they can definitely enact a better law if they want to give more compensation to the land losers in the state of West Bengal. The state has been empowered under the Act to form a better law, but not a land policy. So they don't have a policy regarding that. So that policy is under challenge, And the petitioner says the land will be only given if they acquire under 2013 Act. The difficulty is in the border area. Every day, yesterday also the police came and said that you have to give up the land. But we have not accepted the amount of compensation. Nothing has been accepted. But every day the police mainly are coming and saying this land is required for fencing, border fencing. It's a national issue and you should give up the land.
State was supposed to file a report. Where is your report?
Lordship, here is the report.
Have you served a copy?
No, Your Lordship.
Served an advance copy.
And Your Lordship, in this, the Union of India is also there. They must also.
I am appearing on behalf of the Union of India in respect of item number 21, 22 and 23.
This is
21, 21, all are
Four
identical.
are identical matters. The law point is same, Your Lordship.
Who is appearing for the Jilla Parishad? Someone was appearing on the.
Yes, Your Lordship.
Sir, Parishad.
On the last occasion, Amitabh Chaudhary and N. Roy appeared for the Jilla Parishad. They had appeared on multiple occasions, Your Lordship. But their statement on the last order is recorded, Your Lordship. They are saying, Landed Council for the Jilla Parishad submits that no separate report is necessary to be submitted by the Jilla Parishad, since Jilla Parishad is only an instrument of the state and the report of the state shall suffice this matter. As a policy decision, they are saying they don't need to submit a report.
Yes, what is your report? Do you want to see this report and come back? Or,
Yes, Your Lordship. I want to file exception as because this is a law point. And if Your Lordship only one submission, if the Union of India can come out, because the 2013 Act is of the Union of India. The fact is that no rules have been framed till date. The state cannot suffice that. And they are acquiring land under 2016 land acquisition policy. So the Union of India must say that if this policy is valid or not.
yes, what do you have to say?
Lordship, I have been led by Mr. Shantanu Kumar Mitra in this matter. He is arguing in courtroom number 25, Lordship.
Report
Waiting for
Report in the form of an affidavit submitted on behalf of the state respondents is taken on record. Paragraph copy of the report is made over to learned counsel for the petitioner in court this day. Paragraph, learned counsel seeks to use an exception to the report. Paragraph, let the matter come, appear under the same heading on 8th August.
Your Lordship, only one humble more submission, if the Union of India can come up.
Hello, I have received the report from the department. My lord, I am appearing on behalf of the Ministry of Road Transport and Highway
This
Authority.
is in the next
My lord,
matter, not in this matter.
My lord,
Let me take up the next matter.
according to them, my lord, we have no connection about this matter. My lord, Nadia Jilla Parishad has acquired the land for making the Indo-Bangladesh border road. And my lord, I have received the report, kindly see.
The next matter.
Next
Let me
matter.
just call the next matter.
21.
I am for the petition, Your Lordship.
21, 22 and 23. In respect of three
21,
matters.
I'm appearing for the state respondent. Your Lordship directed to me to file the report in the form of an evidence. Serial number 21, 22 and 23. May I file it, Lord? I wanted to.
7382. Have you served the petition?
Lord, I wanted to serve in the morning, but you said when the matter will be called on, you served it.
He came in the courtroom and so I said, when the matter is taken, we can serve it.
It is yesterday evening only it has been affirmed, Lord. What shall I do? The
The
internet-
Union of India wants to file a report in this case.
Yes, yes, my lord, I have
Yes.
already I have received the report from the department, or you can see the paragraph 3 of my report.
the exception দেবে তো।
Paragraph 3, my lord.
নো পয়েন্ট তোমাদের পলিসিটা তোমরা নিতে পারো না 16 সালে 13 সালে আইনকে বাইপাস করে এটা আমার কেস হ্যাঁ তোমরা 13 সালে 16 সালে একটা ল্যান্ড পলিসি নিয়েছো ল বলছে তুমি একটা বেটার আইন আনতে পারো পলিসি আনতে পারো তোমরা সেটাকে
Policy matter also cannot be challenged.
একদিন জজকে বলেছিল
The union takes no responsibility.
Yes, my lord.
2013 Act is not controlled by them. Border fencing is also not controlled by.
Lordship, border fencing, how can it be a state subject? It's an international subject.
Hey, Josh.
Lordship, prayer A and B of the petition, he is claiming the fair compensation. Fair compensation.
Yes,
My lord, regarding fair compensation, my lord, we have no connection.
we have no connection.
My lord,
It's a central act. 2013 Act is a central act, isn't it? So how is it that the union has no,
Connection.
And your Lordship, the border fencing, how can it be a state subject? Basically the land says it is being acquired for fencing of the Indo-Bangladesh border. And how can state do that? It is central subject.
Yes.
I shall take the further instruction from you.
Border fencing বলছে তোমার subject কি করে হবে? Border fencing state করবে?
বলছি তো যেহেতু জেলা পরিষদ নিয়েছে according to the report.
আরে বাবা এটা তোমাদের ব্যাপার এটা।
If Mr. Ganguly agrees, the state will do it.
My lord.
তুমি কি এগ্রি করছো border তোমরা fencing করবে?
No, certainly not, my lord. Certainly not.
Give me some
Certainly
time,
not.
further I shall
Please
take
come back
instruction.
with a report in the form of an
Yes, yes.
affidavit.
I shall inform the department, my lord.
Learned counsel, report in the form of affidavit submitted on behalf of the state respondents is taken on record. Paragraph. Copy of the report is made over to learned counsel for the petitioners in court this day. The petitioner, paragraph, petitioners seek to use an exception to the report. Paragraph, learned counsel for the Union of India seeks to submit a report in the form of affidavit in this matter. Paragraph, let the matter appear under the same heading on the same date. Same date, 8th.
Yes, sir.
8th August. Lord, 22 and 23 is similar.
Same order.
Yes.
Same. Lord, may I file it? Lord,
Copy served.
let it be
Have
kept on
received the
record.
copy.
Lord, all the reports may kindly be kept on record.
Same order, 22, 23, same order.
22 and 23.
22 or 23.
Lord, the copy has already been served.
I have received it.
Recorded.
23,
Identical.
24.
24, my lord.
My lord, I am for the state respondents. Now, my lord, first of all, I submit that in this matter, the state respondents, on behalf of state respondent, I took several adjournments that may not be appreciated, but the difficulty is this, my lord, this relates to acquisition process of 1945-46. The records, some of the records are still not traceable. So, my lord, I am seeking another opportunity before your lordship. My lord, kindly consider.
But if your lordship may kindly,
My lord, I
usually,
know it's, my lord.
usually I should not oppose, my lord, but for
My lord.
last 3 or 4 occasions.
My lord, I know I sought adjournments on grounds, but
No, your lordship
Going
is,
on
my
for a
lord.
year.
my lord,
My lord,
one
I
thing
know,
your
my
lordship would appreciate, my lord, I am not on that. State has taken a decision to return the land because the act under which it was taken possession lapsed. Thereafter, in view of the death of the act under which possession was taken, it has been illegally retained by the state for 40 years. They have been paying rent compensation to the petitioners for unauthorized occupation. That has also been stopped in 2007 and 8. Now, my lord, the difficulty is that there has been several reports of the joint secretary to hand over possession to the petitioners because they were in unauthorized possession, because the act itself died. And since 2007, there has been several directions
So
by the
last chance I'll grant.
my lord, may
further
kindly
My
accommodation.
lord, my lord, my lord,
Us,
With or without
My lord.
instructions, it will be dealt.
my lord.
my lord,
Kindly.
my lord, I understand.
Learned counsel for the state respondents seeks further accommodation to take instructions in this matter.
No,
Paragraph-
report was directed to file in the form of affidavit.
No,
No, there is
probably
order,
there is
my
no
lord.
such direction.
27
yes.
February, this is my lord, 27 February 2023.
My lord,
Report in the form of affidavit. They took time for that also. 27 February 2023. There was direction, learned advocate for state seeks extension of time to submit report in the form of affidavit as called for. That was also not done.
August.
Paragraph, as a last chance, the prayer is allowed. Paragraph, let the matter appear under the same heading on 9th August should be
My lord.
sufficient.
My lord, kindly make it 23rd of August. I shall ensure that there shall not be any further.
No, it cannot be.
My lord, kindly consider. My lord, because of the, my lord, I should not take that ground, but my lord, kindly fix it on 23rd of August.
18th August.
My lord, 18th, my lord, I have some difficult lordship. Kindly fix it on 23rd of August. Make it clear that there shall not be any further adjournment. I shall ensure that no adjournments is prayed for on behalf of state respondents on that day.
On prayer, let the matter appear to on prayer of the state respondents. Let the matter appear under the same heading
Meanwhile,
on
they will comply with your lordship's
My lord,
direction.
my lord.
August 2022. Paragraph, it is
Well,
made clear that the matter
will
may be taken
comply.
up for consideration even without the report submitted by the state on the urgent date.
Grateful,
Mine.
Your Lordship.
Mine.
Grateful.
Mine.
Yes, sir.
25, 26, Lordship, I am for the petitioner. Lordship, I am very sorry, Lordship. Matter went up to the Supreme Court. As per direction of the Supreme Court, I am paying compensation. My lord, my learned friends, the Eastern Coalfield Limited filed report. My lord, against that, my lord, I have to file exception, but my lord, I could not
Prepare your
the
exception.
Lordship,
Let
till
her
date.
come.
Lordship, I am praying for more.
I have no face to say no to it because in
More
other
time,
matters I
Lordship.
take so much
I
of
am very
time.
sorry, but it has
Perfect,
to,
yeah.
I have to compare line by line what they stated before the division bench and before the Honorable Supreme Court. That is why
Take
I
your
am
time,
taking
take your
time,
time.
Lordship. I am
Take
very
your
sorry, Lordship.
Learned counsel for the petitioners
How's this?
seeks further further extension of time to use the exception to the report in the form of affidavit submitted by the respondents. Paragraph, so I'll give you a little longer time in that case. Paragraph, let the matter appear under the same heading on.
Lordship, so much time granted by your
Yes.
Lordship. So much time granted by your Lordship. I am very grateful.
Please try to be ready on the next
Lordship,
occasion.
Lordship.
23rd August,
23rd
August should be sufficient.
Obliged.
I am grateful, Lordship.
Action.
27.
For the statement.
I am for the petitioner.
Yes. Yes, what is the matter about?
The land of the petitioner, my lord, that has been utilized. Coal India.
Have you served the ECL, the Union of India,
Yes, my lord. Copy has been served, my lord.
agent Kohli is.
My lord, there has been a difficulty, my lord, that the state is not a party, my lord, but copy has somehow been served, my lord. It's the other way around, my
You
lord.
have served the state.
Right,
It's not a party.
State,
Have you
state-
served the person?
Yes, 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 yes.
But I am
Kindly-
for the ECL, my lord.
You're for the ECL, yes.
ICL is the answering respondent, my lord.
And see, my lord, where are the proper
So will you add the state or say them goodbye?
My lord, state, my lord, I don't, my
Has
lord,
no role to play.
has no role to play in
So
this.
you will bid goodbye to them in this matter.
My lord, not a party at all, my lord, no question of my lord bidding goodbye. এটা ভুল হয়ে গেছে। আপনি তো সবেতেই কপি চান বলে দিয়ে দিচ্ছি। My lord, I can, my lord, add them as a party, my lord. Since Mr. Dey, my lord, has already, my lord, has
Mutual
taken the
understanding.
pain, my lord, to go through the brief, my lord, I'll just,
Mutual understanding.
my lord, I'll just add them a party. My lord, that will suffice, my lord. Only, my lord, one thing, my lord, I have to mention, my lord. My lord, my grievances, my lord, in,
What is your representation about? What is the matter about?
my lord, 48
ECL
decimals,
is the requiring body.
48 decimals of land, my lord, direct purchase policy was taken by the ECL in respect of 4 decimal of land out of 48. The difficulty is, my lord, mining operations is going on in 48 altogether. Let kindly seize, my lord, paragraph 8. Paragraph 8, my lord, is my grievance. Of page 4, my lord.
Four decimals have been purchased.
4 decimals have been, my lord, directly purchased, my lord. Direct purchase policy was taken. 4 decimal I, my lord, transferred out of 48 decimals which I own.
And they are enjoying the entire 48 decimals.
Entire 48 decimal mining operation is still going on. That means, my lord, position is, my lord, lying with the ECL, my lord. If mining operation, my lord, entirely goes on in 48, my lord, that becomes unusable for me.
Yes, what is the ECL
one
have to say?
difficulty, my lord. Kindly see, my lord, whether it is with me only or, my lord, with your lordships also, my lord. Kindly compare, my lord, the annexures, my lord, which are annexed, my lord. First, my lord, kindly see, my lord, para 10, my lord. They say, my lord, the petitioner states that considering the above fact, the petitioner by letter dated 11/1/2007 made a representative to the concerned respondent authority. Now, my lord, if your lordship sees para I come to the annexures, my lord. My lord, it is, my lord, a letter date 26/8/2001. But it's not, my lord, 11/1/2007, which they are saying in the pleadings, my lord.
11/1/2007 letter.
Now, my lord, second, my lord, thing, my lord, your petitioner state that after considering the fact and the prayer, the general manager of Eastern Coalfield Limited, by an order date 25th June 2007, my lord. They are saying about 25th June 2007, but my lord, here, my lord, the letter is my 20 March 2000, my lord, P2.
My lord,
But in like this, my lord, I find, my lord, none of the annexes which they have mentioned in the body pleadings, my lord, are annexed with this petition.
my lord, may I, my lord, take your lordship through paragraph number 10, my lord. Your petitioner states that considering the aforesaid as a petitioner by letter dated such and such 2007 made representation to the concerned respondent for outright purchase of the said land in plot number 123. That means, my lord, the remaining 44, measuring about 44 decimals of land. Your petitioner further states that in the year 1998, the respondent authorities by memo dated 1998 requested the district register to supply the copy of the deed dated 54 as plot number 123 is required for company's direct use. I have, my lord, annexed the copy of the memo, my lord. Kindly see his representation and the memo, my lord.
So you have not annexed this 11th January letter.
Not only these, my lord, P3, P4, P5, I am not finding anything, my lord. As my lord pleaded over here, my lord. I don't know, my lord, whether it is with my copy only or not, my lord. It might be by a mistake, my lord. Kindly cease, my lord, also all the pleadings, my lord. Like, my lord, para 13 also, if you will also consider, my lord, he is saying about, my lord.
Best person to show that these annexures are there in the.
My lord, I think, my lord, a supplementary affidavit, my lord, is required, my lord. My lord, some annexes have been missing.
Some, no, my lord, all annexes, my lord.
Not all, my lord.
Kindly find out one annexure for me.
My lord, my lord, my lord.
Mr. Dey, let him come back.
Yes, and in the meantime, leave may be granted, my lord, to add the state as a party, my lord.
Affidavit of service. On prayer of the petitioner, leave is granted to implead the state of West Bengal as respondent number 7 in the writ petition. Paragraph, the cost letter of the writ petition be amended accordingly. Paragraph, the petitioner is directed to serve copy of the writ petition along with annexure thereto upon the added respondent.
We have already served.
And there should be an order. He has served prior to adding you. That was official. That was unofficial. This is an official recording. And file affidavit of service on the adjourned date. Paragraph, learned counsel for the petitioner seeks to use a supplementary affidavit annexing relevant documents. Paragraph, such liberty is granted. Paragraph, let the matter appear under the same heading on 10th August. Please serve advance copies.
Yes, certainly.
801.
28.
My lord, similar.
28.
28 I am
to appear on behalf of the respondent number 225. Lord, what I find is the prayer is consideration of his representations. Lord, can pass an order in this regard. My lord, what I will only seek is, my lord, a 12 weeks time be granted as to pass.
12 weeks?
My lord, the difficulty is that these records are very old. And for this purpose, my lord, we are facing a lot of difficulties in getting all the papers in one place and thereafter proceed with the orders that has been passed by my lord. So, my lord, for this reason only, I'm seeking this 12 weeks time, my lord. His prayer is, sir, page 20. Page 20. Page 28.
Here also state is not a party.
State is not a party. What I
But
find
state
is,
has been served.
State has been served, my lord, and I appear.
my lord, it can be disposed of. Page 14 is the prayer what he is seeking.
Page 14.
Yes, my lord.
1.
Page 13 and 14.
13 and 14 is
prayer-
the prayer. Yes.
Prayer. So, my lord can dispose of the writ petition on the basis of this prayer B. And the annexures which he is relying upon as
Similarly stands, my lord. If a lordship, my lord, takes the matters, my lord, on the same date, my lord, it would be, I think, better, my lord.
Where is your representation?
He starts from what I find from page 26, my lord.
Well,
Page
since, my lord,
26, page 28,
My lord, most of the annexures, my lord, would be similar, my lord, because the both of these petitioners, my lord, they sent, my lord,
Respondents are not concerned with your annexures in this matter.
in this matter, my lord. Because what he has ultimately sought for, although
Page
we have
26 is the demand of justice.
my demand, that is his, my lord, what he is seeking consideration of the demand of justice. From page 26, page 28, page 30 is our reply, which I find, my lord, addressed by Eastern Coalfield Limited. But the page is such, is not at all legible. So, my lord, if I try to read out, that it is to draw to your kind notice that it was addressed by the Eastern Coalfield Limited to one Abhay Chandra Bhattacharya, advocate, means, sir, thank you. Thank you, sir. Means the advocate for the petitioner, where we have indicated that this is to draw to your kind attention notice that a reply in respect of your above named client sent to you on such and such by register through panel or advocate official Shri Piyush Kanti Das as desired by on behalf of your clients by such and such. Further, one copy is submitting before you the undersigned on behalf of GM Kajuria as desired by you with reference to such and such as subsequent later such and such signatories. My lord, the
You
later
have
I
asked
find
for
has,
employment also.
no, my lord,
You're asking for employment also.
but employment, my lord, that prayer, my lord, at this juncture, my lord, I am not pressing, my lord, my kindly seize my prayers, my lord, in my writ petition.
Either comprehensive representation, my lord, that will be considered by.
What I find is the representation which he has My lord, prayed kind- for is only monetary compensation.
Yes, yes.
There is no
He's-
prayer for,
He's
yes,
praying for that only.
my lords.
Will you file a comprehensive representation?
That I can do, my lord. That I'll do.
Your land has been acquired, but no compensation paid.
Yes, yes. My lord, land has been acquired, my lord, in respect of a portion. The other portion is also being utilized for mining purpose. That will be disputed because consideration, let it be considered merits. Because we have already replied to that, as I find from their document. May I, my lord, suggest, my lord, on the, my lord, the ECL, my lord, can come back with a report, my lord, it would be, my lord, why, it is, my lord, better, my lord, to dispose it of, my lord, on similar terms, my lord. But it is of no use.
What report will be required?
My lord, the otherwise they also ought to have placed the representation or reply which we have addressed to them as indicated in page 30 of their writ petition. Page 31. 31 নেই আচ্ছা আচ্ছা নেই আমিও দেই একই এই 30 আছে The paragraph 3 here, the Eastern Coalfields have already indicated the reasons. It is with regard to most probably the employment part.
Here it is not your case that a portion was acquired and the entire portion is being utilized.
পূর্ণিমা অধিকারী আপনাকে my lord, kindly seize, my lord. Paragraph 3 we have replied given the reasons here at page 31 if it is available in my lord's copy which was indicated in page 30 that your clients nominated Sri Shantiram Odhikari after the use of the said land and the alleged deed of adoption that is dated 4/11/2003 is not a registered deed and the same cannot be accepted as a valid adoption as per the provisions of law. Moreover, the alleged adoption was never acted upon as will be evident from the educational certificate where the father's name of Shantiram Odhikari has not been changed and the name of his natural heir father still stands and as such the purported adoption cannot be accepted as a valid one. That in view of the above, the demand of employment to the nominee of the owners who claim to be adopted son of Srimati Purnima Odhikari, wife of Sri Haradon Odhikari has got no merits for consideration. So what I find is that that is not praying for. So now the part monetary compensation remains, my lord. Let be direction, my lord.
Yes, where is your case in the writ petition that portion has been acquired and entirely it has been utilized? No, there is no such case. So this is not, it's different from the other matter.
And very first page of the petition, the annexure, page 17. Here also the circular which has been annexed or policy which has been annexed is with regard to the employment opportunity. What I find from the policy manual. But at page 20,
My lord,
I must
kindly see,
point
my
out.
lord, paragraph number 12 onwards, my lord, of my petition, my lord, page 7.
Yes. This is land, the entire land.
My lord, entire, my lord, land was utilized with the impression that, my lord, employment would be, my lord, at a subsequent stage.
You just now said that they have taken a portion of the land, but they're
My lord,
utilizing
my
that.
lord, my
That
lord,
is
stand
not the
corrected,
case. here.
stand corrected, my lord.
So file a comprehensive representation.
That state will be granted to.
On prayer of the petitioner, liberty is granted to implead the state of West Bengal as respondent number 7 in the petition. Paragraph, the cost of the writ petition be amended accordingly. Paragraph, the petitioner is directed to serve copy of the writ petition along with annexure thereto upon the state respondent, and file affidavit of service on the adjourned date. Paragraph. একটা line করো, এই petitioner is directed line টা কেটে দিন। Petitioner is directed to serve বললাম না, ওই লাইনটা কেটে দিন। Since copy of the writ petition along with annexure thereto have already been served upon the, has already been served upon the state respondent, comma, further service is dispensed with. Paragraph, heard learned counsels for the parties. Paragraph, the grievance of the petitioner is that his land was acquired and utilized by the Eastern Coalfields Limited and mining operation is being carried out in the said land. Stop. No compensation has been paid to the petitioner as yet. Stop. The petitioner seeks to submit a comprehensive representation ventilating his grievance before the concerned authority and prays for a direction upon the authority to consider the representation at the earliest. Paragraph. It is submitted on behalf of the respondents that who should be the authority?
My lord,
General manager? Or the chairman? Who should be the
no, chairman.
Chairman?
It will be.
The third respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the writ petition is disposed of with liberty to the petitioner to submit a comprehensive representation before the third respondent within 7 days.
My lord, 14 days,
15 days. Within 15 days from date. Stop. The third respondent is directed to consider and dispose of the representation within 3 months you want. Within 3 months from the date of receipt thereof, upon affording reasonable opportunity of hearing 3 months. Upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph, in the event the petitioner is found entitled to compensation, comma, such compensation shall be disbursed in favor of the petitioner within a month thereafter. Disposed of, Richard.
My lord, the usual paragraphs not gone into the merit.
That.
Grateful, man. Great.
You have learned. Next.
29.
29.
I beg to appear on behalf of the writ petitioner, my lord. But kindly recollect that in this matter, my lord, the writ petitioner, my lord.
Just a quick correction. Last since service has been made, before the service is dispensed with at the line of state cat for the service to people. Service same service since copy already served for them, the company dispensed with. add for a problem. 27. Yes.
Yes, my lord. Kindly recollect in this matter. Writ petitioner, my lord, wants to, my lord, set up a, my lord, poultry farm.
Want to first?
Poultry farm.
Yes.
My lord, less than, my lord, 3,000 bird. So, my lord, they have filed, my lord, this matter, my lord, is a checkered history because the private respondent, my lord, came before this honorable court for, my lord, removing that poultry farm. They are saying it's an embankment, my lord, of a pond. So, my lord, last occasion, my lord, I have submitted that DM, the matter relegated back to the DM to consider. The DM has not considered, my lord, the notification which is appearing at 54. There is page 54 of my writ petition, government notification. My lord, 55. So they are supposed to, my lord, argue on this point because
Ask me to take instruction or we have received instruction.
every time, my lord,
It's my instruction. My lord, DM has considered the issue, my lord, pursuant to the order passed by this in appeal matter. And pursuant to that order, my lord, the construction has been removed, my lord.
may I take a report? My lord? Okay.
He needs to see the a copy
Yes,
of
ma'am.
the.
The same thing he has written, my lord. The order, the last occasion is that same thing, my lord, handed over to your lordship.
So DM has passed the order, my lord.
I have challenged the DM order, district magistrate order, that it is, my lord, non-consideration of a particular guideline. Government guideline is, my lord, also, my lord, arbitrary and unreasonable. My lord, page 55 is relevant. It says, my lord, if, my lord, birds are more than, my lord, 5,000, then it cannot be.
Yes.
Yes, that cannot be, my lord, 55. The said guidelines of term poultry unit refers to hatcheries, including custom hatcheries, breeding farms, layer, broiler farms, rearing fowl, duck, etc., which are handling 5,000 or more birds. 5,000 is the, my lord. My lord, contention is that the petitioner wants to set up a poultry farm less than, my lord, 3,000 birds. So, my lord, there is no legal embargo. That has not been considered. There is no whisper in the, my lord, order of the district magistrate. 17.8. Inland Fisheries Act 17.8.
'59 is your representation.
59 represent that has been considered the impugned order as page 70. Your lordship may relegate this matter to the DM for a fresh consideration, considering all the guidelines, government guidelines. Inland fisheries. Is required.
You're already occupying that portion of the land.
Yes, after getting permission from the concerned panchayat, my lord, they have given no objection.
Is it Panchayat land?
Panchayat land. Not Panchayat land, it is a land belongs to the British private land. I have given, my lord, I have taken permission from the Panchayat
Start the business.
to start this business.
Yes.
But from the impugned order, it is not appearing whether, my lord, 18th of July 2016 notification has been considered or not. Whether it has been placed before the district, that is also not, my lord, appearing, my lord.
What is, which?
My lord, the page 54, the notification where they are relying on.
It's your notification.
Yes, but whether that has been considered or that is not appearing from the impugned order, it is true, my lord.
When it is not available to the petition at that relevant point of time, their duty is to produce this. They are the
They are
state.
not-
They are not any private party. They have to give a clear picture to the.
My lord, kindly direct the, my lord, district magistrate to consider whether this notification is applicable in case of the petitioner.
Yes,
This
considering
much,
all
my
the
lord,
notifications.
without our setting aside
Yes.
this order, my lord, because
Yes.
this order has been passed pursuant to the order passed by this honorable court, my lord, in a appeal matter. So only these notification is applicable or not. That is their case, my lord. If this is applicable, then, my lord, appropriate step will be taken, my lord.
Yes, my lord. Yes, submission.
Let the DM consider whether this
Yes,
is.
considering all the my lord guidelines,
Yes.
relevant guidelines.
The order. Impugned, the order passed by the District Magistrate Bankura on 9th June 2022 is impugned in the writ petition. Paragraph, it is submitted on behalf of the petitioners, that the petitioners intend to start a poultry farm on the land purchased by them by virtue of a deed dated 6th April 1978, along with pond, tree and embankment. Stop. The petitioners received a no objection certificate, obtained a no objection certificate from the concerned panchayat for setting up the poultry business. Stop. Pursuant to public interest litigation, pursuant to an order passed in a public interest litigation being WPA within bracket P 366 of 2021 on January 17, 2022, 2022, directing the concerned authority to carry out spot inspection and demarcation, if required, and take immediate action in accordance with law in the event any encroachment on the pond for public use is detected. Any encroachment on the pond for public use is detected. The district magistrate, by the impugned order, directed restoration of the plot Talpukur inverted comma, at Moja Borajpota, Borajpota, comma, jail number 95, comma, plot number 375, to its original condition. Stop. Paragraph. Learned counsel for the petitioners submits that the notification issued by the Department of Environment, Government of West Bengal on 18th July 2016 demonstrates the relevant part.
My lord, 55. It says, my lord, in such situation, my lord, it cannot be opened. If it's
But they are
1,000
sufficient,
and-
but this notification is not applicable in case of the embankment of a pond, my lord. Nowhere from this notification appearing, my lord, they could establish the poultry farm in the embankment of a pond, my lord. Then
My lord,
order
it
has been
says, my
passed
lord,
because they have, my lord,
sitting by a criteria is there, my lord. Sitting criteria.
It should be 100 meters from major water course like rivers, canals.
Even if it is 5,000 more, it can be done.
can live in a direct.
Poultry farm should be 100 meters away from any water
Yes,
body.
it can be done. If it is more than 5,000, my lord.
Embankment also
My lord,
includes
kindly
my lord, the
consider
definition of a pond, my lord.
embankment is a my lord, huge plot, more than my bigger.
Maybe, but
There's
that
a
is
school is
referred
also
as
there.
embankment of pond that includes not a water body.
No, this 5,000, this 100-meter bar is for all poultry farms, not only 5,000.
Yes, my lord, it is applicable, my lord. Applicability of this notification.
Page
55, my lord, first paragraph. In the state guidelines, the poultry farm, poultry units.
refers to hatcheries,
Yes.
yes.
Yes, hatcheries, breeding farms, layer, boiler farms, rearing fowl, duck, which are handling 5,000 or more birds. Now, we are, my lord, only for 3,000, less than 3,000.
This guideline is not applicable in your case at all.
Yes, my lord.
Why will the DM consider this guideline?
Because, my lord, what I am saying, my lord, this guideline says, my lord, if it is 5,000 or more, then this criteria,
It's not applicable in your case. You are not guided by this guideline.
it
You
is
are
safe, my
guided
lord,
by the order of the PIL only, PIL only.
PIL has not decided anything, my lord. It is relegated to the, my lord, DM to consider the representation of them.
Yes.
If there is any, my lord, block, then the necessary action will be taken. That order is passed. So,
The
this,
DM need not take into consideration this notification at all. Because this is, you are not guided by this. You are not-
again read, my lord.
Yes.
Again read this guideline, my lord, why it is applicable to me. Because, my lord, again, I am saying that, my lord, my poultry farm is less than 3,000.
Since it is less than 3,000,
Yes.
this is not applicable to you. And-
Even, my lord, if it is 5,000 and more, it can be done.
The guideline says 100 meters, but the PIL says otherwise. PIL says no construction.
So
on the
there is no such,
impact
DM has not made such an effort before passing of that order.
is-
That where it is located, whether it is 100 meters away from,
Has any
whether it is
for the order?
Yes, my lord. My lord, it is appearing from the order that they have, my lord, they have also admitted that the, my lord, the poultry farm has been set up on the embankment of a pukur bar, my lord, pond.
it says
And
on
that
100 meters,
includes
even
the, my lord,
5,000 and more, it can be done. Out of 100 meters.
It can be
away
done on the embankment of
from
pukur,
the
my lord.
pond.
That is not appearing from this notification.
I can put in this way, my lord. Suppose, my lord, I have, my lord, a poultry farm, 5,000, my lord, handling 5,000 more birds.
Bring this out. 5,000, 3,000 is not the issue here.
No, I'm saying, my lord, let me, my lord, submit 5,000 and more. Even then, my lord, I can, my lord, put in the embankment because, my lord, if it should be, my lord, 100 meters away from the pond.
Yes,
Pond.
but
So that my effort has not been made by the DM.
because your poultry farm is less than
No, that is
5,000.
not, my lord. My instruction, it is far away from the pond.
Poultry farm is less than 3,000. So this is not required at all in your case. The notification is not applicable in your case at all. It is less than that.
So
Notification is applicable for cases where the poultry farm has more than 5,000 birds.
more than
Yes.
5,000.
Yes, so this is not applicable. Yours is less than 5,000.
Less than.
Admitted. That is
That's
not
why I'm
mistake.
saying, well, even well, 5,000,
The PI says that there will be no construction on.
because they are saying, well, what is the well, nature of the PL? Because it is well, creating well, environmental pollution. If my 5,000 well, is not creating any
It also create environmental pollution.
even well, 5,000 well, it is it can be done.
5,000 is not the issue at all here, sir. It is the PIL.
But that has not been highlighted in the ballot. Ballot in the PL has not been decided anything.
It says it is a Rayati pond for public use.
Pond.
Yes.
Yes.
You filed a representation before the DM?
Filed.
That has been considered.
That has to be considered. That has been considered and plus the impugned.
And was any spot inspection or verification done?
But it appears from third paragraph of my report, my lord, statement of facts, my lord.
Only BLR have filed a report.
Last two line, my lord.
So this is basically a quarrel between two private parties.
Yes.
Yes. Who has only raised this?
Third paragraph.
Yes, my lord. Third paragraph, I see. My lord. Last two line of third paragraph, a child training center, my lord.
Yes, there is also child
A
training
primary
center.
school are located just 150 meters away from the said construction. The village is also located just 150 meters away.
An inspection was held. Was it held in presence of the petitioners?
And that is I do not have. The documents is also not with me.
Because the petitioners say the poultry farm is not on the water body.
This is on the water body. My lord. Embankment is includes my water body. My lord.
Yes, embankment.
Yes, and they are admitting, my lord. They have. set
That
up
is
the-
the record says it's an embankment, but it's a huge land embankment.
Rec-
There is also government school is there. That is Shishu Shikha Kendra.
different.
That is a different issue. That is the subject matter of the writ petition. Because they are doing something wrong, you cannot be permitted.
Well,
to-
kindly consider in the appeal, with greatest respect, I'm submitting before your lordship. The court has not gone into the environmental issue. Court says only, if they are in this block of the plant, by the private respondent, that can be removed.
Pond or embankment.
No. Taken statement. Only pond it is there. Page 39, my lord. Second paragraph, my lord. In case if any encroachment on the pond for the public.
And my lord,
So where is the encroachment on the pond?
can you see, my lord?
Pond
it's
includes
a pond.
embankment.
Yes, my
That
lord.
is the definition of pond.
Yes, ma'am.
No, embankment, no, last occasion I have submitted to be heard, lordship. There is embankment definition, your lordship will not find in any statute. Only there is one statute, my lord.
There is a
Embankment,
notification
my lord.
The definition of pond includes embankment. Embankment is not defined separately.
Embankment defined, yes, my lord. That is Bengal Embankment Act is there. 1882. It is still in force.
Do you have the books with you?
My lord, section 3, my lord, can be considered.
Do you have the Inland Fisheries Act?
Inland Fisheries.
Inland Fisheries.
বন্ধ করলো কেন?
Fisheries Act. Fisheries Act. আছে নাকি? You have the Inland Fisheries Act with you?
Yes, my lord. Pond has not been described. my lord.
You have the Inland Fisheries Act? Water body has not been described, defined.
In any way, my lord, it will not disturb the pond, my lord.
This chapter.
Then, my lord, that Shishu Shikha Kendra will go. Then
Yes,
Shishu Shikha Kendra will also grow. It is encroachment on the pond.
maybe if the DF desires.
But that's why, my lord, this is, my lord, embankment. My lord, embankment has been defined in this act, my lord, 1882. Kindly consider. Pond and embankment are different
Chapter
connotation.
3, my lord, I have my lord, annexed on documents, my lord, in my report, my lord. Last my lord, page, my lord, 5,
Yes.
the 6th month of 2007. This is the my lord, letter, my lord, to the my lord, district land and revenue officer, my lord. In reference to the above, his attention is drawn to the chapter 3A of the West Bengal Inland Fisheries Amendment Act 1983 that puts a bar to conversion of water area, etc. for other use and even to the filling up of any water area, including embankment.
Where are they reading? Page 5.
Page
My lord,
5.
he is referring, my lord, section 17 way, which, my lord, landed, my lord, district magistrate has considered.
Yes, madam.
We are not filling any, my lord, pond.
Page 5.
It
No.
includes embankment, my lord. Page 5 of my lord.
It bars only filling up the
Print
pond.
of facts, my lord. It's not
Reference to your query, page 5 is a letter dated 19 June.
6th March of 2007, my lord. 6th March.
My lord, that is, he has quoted from 17A, my lord, your lordship, from inland fisheries.
There is a my lord, clear bar in the my lord, inland
Where
fisheries.
is it? Sir, I'm not getting it.
My lord,
This, the,
in my lord, report, my lord, I have handed over my just to my lord.
this page he is reading, my lord.
Page, my lord, 4.
Page 4.
Page, my lord, 5, my lord.
This page he is reading. It is not.
Page 5. my lord. The letter is 6th March of 2007, my lord. It's not legible, my lord.
It is no one case that I am filling, my lord, pond.
It's conversion of water body.
Yes.
What connection does this have with the present case?
Uh,
He's making his
But
construction.
it appears that the my lord, embankment of pond includes the my lord, pond. That
It's stated. Please show me.
that is all that will appear from the my lord, Inland Fisheries Act, my lord, chapter 3, my
The
lord.
17A, my lord, kindly consider. 17, section 17A. It says, my lord, for filling up the pond and, my lord. In that sense, my lord, it is also considered that it is embankment.
That is bar to conversion of water area.
Yes, my lord.
I have not converted, my lord. No one case it is that I have converted. That's why, my lord, that guideline is there. It should be 100 meters away from the.
Where does it say that this is a bar to conversion?
Bar, my lord, this is a bar.
Bar to conversion.
That
He's starting a poultry farm in his own land, which is
land, my lord, is all embankment. That is, my lord, not permissible, my lord. Embankment of pond, setup of 45 is not permissible.
where is that?
Where is that?
Where that law?
Can you sir come, my lord?
He's not filling up the water body.
No, it's not filling, my lord, but they are setting up.
There, he's setting up a poultry farm there.
That is not permissible, my lord.
How do you say that is? You cannot say just that is not permissible. In terms of which law, it is not permissible.
Then I shall come, my lord. I shall come, my lord.
Yes, please come back with instructions.
See, my lord, kindly consider, my lord. This matter is pending, my lord, for how many months?
The matter is such that it has to be dealt with, isn't it?
My lord, next week, my lord, kindly please.
No, not possible. Written instructions submitted on behalf of the state respondents is taken on record. Paragraph, the learned counsel for the petitioners submits that the petitioners intend to start a
My lord, may I intervene only one thing?
তো কি এটা বলেছি এখানে ঠিক আছে এগুলো পরে করে দেবো লাস্ট লাইনটা কি বলেছি uh, 16 demonstration কেটে দাও তারপরে এগুলো করছি 16 has not been taken into consideration by the district magistrate while passing the order implemented. মাঝখানেটা কেটে দিন যেটা বলছি paragraph learned counsel for the petitioners paragraph the petitioners seek to start a poultry farm on the embankment belonging to them and do not intend to fill up any water body. Paragraph learned counsel for the respondents seeks to take further instructions in this regard. Paragraph, please take specific instructions.
May I,
What provisions of
Say
law?
has to be supported by a law.
Yes, yes, sir, definitely.
my lord, may I submit one thing, my lord? My lord, only ground for rejection, my prayer is my lord 17A.
15, yes.
And 17A has no manner of application. My lord. Neither I am digging, neither my lord I am filling up the pond. So my lord, in that case, my lord, 17A is no manner of application. And he's saying that
I'm taking
this is a bar. Then he will put a new case here.
Yes, yes.
He's putting a new case here. Then
Let the matter appear under the same heading on 3rd August.
at fair top, my lord.
It will
Top.
be- It's being taken up.
Kindly mention my lord top, my lord, because
Cannot be mentioned, it will be taken. Yes, next one.
Thank you, sir.
মাঝখানে বললাম ওইটা ব্র্যাকেট করেছি instructions submitted on notice capital and account.
my lord,
তারপরে instruction
my lord, instead of my lord 3rd, my lord 4th August. my lord. Fourth.
fourth code.
Right. বইটাও দিন, বইটা।
Next.
Number 30.
Alpha district. That's hard. The recently, my lord, I was also served. The current evidence service, my lord, has not been, is ready, but it will be affirmed, my lord. After hearing, my lord, I will.
Affirmed হয়নি, ফেরত দিন।
Lord, this is a matter, my lord.
This is on the private respondent,
Yes.
served.
Lord, 2 times, my lord, I have served. Currently, my lord, also, my lord, I have sent notice.
Up to or no?
Yes.
देखिए तो माइनर को दिए था देखने का पड़ेगा बताओ जाओ ना माइनर विरोध तो वो देखे चेकअप
But it's a matter, Lord, in which Lord, there is a road, Lord, leading from Lord Borji to Bhaddeswar station, Lord, in Bhaddeswar area. Lord, what happened that by the side of the station road, there is a particular plot of land which has already been acquired by the PWD
I'm
authority.
sorry, please show me the other affidavit. Because here it was not served. Here also it is not served.
Lord, last, another letter is there, Lord, Lordship kindly sees.
Dispatch to be due.
But previously, Lord, you have served item delivered.
This is 899 and you are showing 945. Oh, 945 is the earlier service.
Yes, yes.
Very good.
Not what happened. That, my lord, in this matter, my lord, I post 65 admit. My lord, I submit the report, my lord, in the report, my lord, assistant, my lord, assistant engineer, my lord, pay for demarcation to the SDL, that is the.
The SDL?
Yes, my lord. Perhaps there is SDL or is the SDL up till now, my lord, did not give the report for that reason that was. PWD roads lands, my lord, that was encroached by the private respondent. For that is they come before your lordship, we filed an application before the assistant engineer, my lord. So to claim for. My lord, in 6465, my lord, this particular landlord was acquired as stated in paragraph 3. I have given also the LA case number, page 4. This is LA case number 2149 LA, PW dated 9/12.
This is now PWD land.
Yes, the PW. Now, my lord, the private respondent have encroached in such a fashion that, my lord, it's at the corner of the road. It blocked, my lord, a portion of the road and narrowed the road in such a fashion, my lord, it's creating disturbance. That is the admitted position. Yes, yes. Now, my lord, the issue is, my lord, that is to be demolished by the PWD authority. My land senior friend, my lord, is stating that already, my lord, SDLR, my lord, has been directed to demarcate which portion is encroached and which is, my lord, not in. So, my lord, let, my lord, a specific time, my lord, be given, my lord, within which, my lord, let them complete the process and process.
Demarcation within 1 month and
Yes.
within next 2 months, the proceeding will be over.
Proceeding, my lord, to be completed.
Okay. And please file your affidavit of service after
Yes,
upon
within 15 minutes.
affidavit of service. The petitioner complains that the private respondent has raised unauthorized construction by encroaching upon a considerable portion of the PWD land adjoining his property, thereby obstructing his passage, his egress and ingress, obstructing his egress and ingress completely. Stop. The petitioner submitted a representation in this regard before the concerned authority on 7th July 2022, which is 22, and prays for a direction upon the authority to consider the representation at the earliest. A paragraph. It is submitted on behalf of the state respondents. শুরুতে করে ওটা non-appears for the private respondent despite service of land advocate. It is submitted on behalf of the state respondents that pursuant to the representation submitted by the petitioner, the assistant engineer, Chandannagar Highway Subdivision, PW within bracket roads, requested the subdivisional land and land reforms officer, Chandannagar, vide his memo number 439, dated 22nd August 2022, to demarcate the right of way of the said PWD land as per government records. Stop. Such demarcation is yet to be made.
My lord, leave is granted to add subdivision land and land reforms officer as a party of the person. He is not a party in this.
Special land, the assistant engineer is there.
No, my lord, subdivisional land and land reforms officer. He is not a party. What that is, my lord, your lordship was pleased to
So let
direct.
this person be added as a.
Yes, my lord, leave is granted.
Let him be added as.
Yes, yes, right.
Paragraph, in view of the above, this court is inclined to hold that since the subdivisional land and land reforms officer, Chandannagar, has been directed to demarcate the allegedly encroached land, comma, the said authority be directed to complete such demarcation and submit a report to that effect before the assistant engineer, comma, being
Respondent
the
number 4. The respondent number
Third.
3.
third respondent herein within 1 month from date.
Yes, ma'am.
Upon receipt of such report, comma, in the event of encroachment upon the PWD land or any portion thereof is detected, comma, the third respondent is directed to initiate proceeding under section 10 of the West Bengal Highways Act 1964 and take the proceeding to its logical conclusion within 2 months thereafter, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondent, comma, in accordance with law. And disposed of which chapter 9? একদম শুরুতে করুন affidavit non appears for the private respondents তার আগে করুন on prayer of the petitioner liberty is granted to implead the subdivisional land and land reforms. SDLR is subdivisional. Land and land reforms officer Chandannagar Hooghly as respondent number 6 in the writ petition. Paragraph, the cost title of the writ petition be amended accordingly. You want to take back the offer?
Yes, ma'am. My lord, that will be kept in the record, ma'am, because
So the instructions submitted on behalf of the state respondents is taken on record. Instruction taken up.
At number 32.
But I appear for WB hit comment in this.
Lord, I am the petitioner. I'm paying for not today, my lord.
But there is really no scope for any interim order. We would anyways have to pray for time to file an affidavit. This concerns demarcation of a plot where your lordship had the occasion to consider a similar plot in a different writ petition. That order they have also annexed. My lord's order.
You are appearing for?
I'm appearing for WB HITCO. Demarcation has been carried out in 2022. We need to place everything on record by an affidavit.
Come back with a report in the form of an affidavit. Why affidavit? That will only delay the matter.
Well, whichever your lordship.
Petitioner?
Lord, I am the petitioner. I'm paying for not today, my lord. In this matter, appearing Mukteshwar Maiti. She engaged in another court, ma'am.
Have you served the third and fourth respondents?
Yes,
Who are
ma'am.
they? Where is your affidavit?
LA collector is the main respondent. Concerns a demarcation of a land, a portion of it was acquired, portion unacquired.
Come back with a report in that case. You are for 3 and 4, isn't it?
I am appearing for my lord. No, I mean 3 and 4. I am appearing for 3 and
1 and
You also need to file a report.
they have
They
paid
need-
for demarcation, my lord.
It's not necessary.
They need to because they have carried out the demarcation. The
LA
LA collector has carried out the demarcation in presence of HITCO and yes. On
Lordship
somebody
director
else's
shall
writ petition.
If your lordship directs us, we shall file report, my lord.
They have to. Because in the other matter also, they had filed the report
Please come back
indicating
with the
demarcation.
report. Let us see what is there.
Demarcation report, my lord, that I have to take so whether demarcation is done or not, my lord. But they have paid for demarcation.
Our instruction, the demarcation done on
That has been.
7/12/22.
Council says that such demarcation has been done already.
Yes, on 7th of December 2022.
They have to take instruction.
Please take, let me take instructions and come. It is submitted on behalf of on behalf of the third and fourth respondents that demarcation as sought by the petitioner in the present writ petition, petitioners, has already been done on
7th December
7th
2022.
December 2022. Stop. Learned Counsel seeks to submit a report in the form of affidavit in this matter. Paragraph, Learned Counsel for the state respondents also seeks to take instructions in this matter. Paragraph. Learned counsel for the petitioners seeks accommodation. Paragraph, let the matter appear under the same heading on 10th August.
And report to be filed in the meantime. Great.
Please serve advance copy.
Absolutely.
33.
33 minutes. There was direction to file report in the form of affidavit. It has not been filed.
I am appearing for the state
The
respondent.
dispute is, my lord, that
No, report is there, but I have got the, state. I have got the instruction, Lord. Instructions of past December 2022. Now the, what it has been written, the several attempts have been made and it has been
No.
found that deed in question, Lord. It is in the name of Himanshu Shekhar Bera and three others. Not your lordship, kindly see the last only. I am not inclined to hand over, but only see the last one. Last, only the last paragraph of my instruction. It is not a report, not if your lordship so desire, I will file a report. Your lordship, only the last one, last paragraph only. Whereby and wherever only the various general ideas also enunciated. What are in the pairs?
Is your deed number 904?
904. Your lordship will find it in page 34. Page 34 is representation. At the inception, you will find. Page 32, your lordship P5. Your lordship can you see? Speaking over the first line, that by virtue of the registered deed being 904/1959, duly recorded in the volume number 12.
Yes.
This, so this is my instruction, Lord.
possibly
যেটা আছে
না ঠিক আছে এটাই আপনি affidavit করে ফাইল করতে চাইলে করে দিন।
এইটাকেই বলেছি।
Please come back with a report in the form of affidavit,
If your
because
lordship may once look to,
this is the very basis of the
if your lordship may once look to paragraph 3 and 4
of
the writ application, this is the mutation of the state respondent with respect to the property described in paragraph 3. Therefore, all that I am concerned is with respect to my property, and copy of the deed and mutation I have already annexed in the writ application. Your lordship, my lord, directed therefore on 30th January 2023, there were two directions. One, they say that in 2013, they couldn't find the record and they have lost their diary. In 2019, they also say that they have again lost their diary. That was made clear by your lordship's order on 30th January 2023. Let them, my lord, file a report with respect to the statements contained in my writ application and the documents annexed.
What is your deed number? 904.
My lord, they did, I mean, mutation certificate of the
904.
paragraph 3 and paragraph 4. With reference to the statement made in writ application.
Paragraph 3 is deed number 904.
Yes.
I will come back with the report. No
But
issue
you
with
have
that.
granted mutation on the basis of this deed.
Then I will come back.
With
No, this is a
respect
very
to the-
old matter.
Same property.
With respect to the statement and documents annexed in it, let them file a report so that it
I'll come.
comes clear. Lord,
I just now I talked to the district register also. They are not in
Because
knowledge. They said we will come back.
in
Whatever
2013,
I got not, I have just shown it to my lord.
for 7 years, there has been no improvement. No, no, আমি বলছি না, আমি বলছি না, for 7 years, no development.
Learned counsel for the
30th January 23,
respondents
the direction was passed.
seeks extension of time to submit the report in the form of affidavit as called for. Paragraph, let the matter appear under the same heading on 10th August.
My lord, one thing, if your lordship may kindly add, with respect to the statements and documents annexed in my writ application, let them, because otherwise it will not serve any purpose to me. Grateful. your lordship.
বাইরে গিয়ে আমাকে যা যা বলার বল আমি
না,
সব
না,
করবো।
আমার রিটটা দেখে খালি বলুন না।
যশ সাহেবের কাছে যদি কিছু বলতে হবে।
অন্যটা দিয়ে I am not
Very good
confident.
fellow. My old fellow, he used to work with me when I was in the central bank. It's very good. Lord. Good, very good.
Grateful.
So, বাইরে sir.
34.
For Millard, I am for the petition.
Yes.
Millard, I am for the private respondent, Millard.
This is my affidavit of service.
State has been served.
Yes, ma'am. This matter relates to unauthorized construction.
Mr. Dev. Please serve a copy to Mr.
This matter relates to unauthorized construction made on the land of Irrigation and Waterways Department by the private respondent. The petitioners made representation due to inaction on the part of the respondent authority to take steps on the basis of the representation. The petitioner sent a legal notice, but thereafter no steps have been taken to remove the same. Now kindly come to page 29 and 30 of the writ petition.
This is your demand of justice. Where is your representation?
Page 31.
Can it be deciphered? Is it legible at all?
May I read, my lord? In the last paragraph, আগামী দিনে সমীর কর্মকার পিতা তিনকড়ি কর্মকার, here is the private respondent, জামালপুর যাহাতে বাঁধের উপর কোনো প্রকার কনস্ট্রাকশনের কাজ করতে না পারে তার সুব্যবস্থা করিয়া বাধিত করিবেন।
Lord, I have a preliminary objection to this writ.
Yes, what is it?
I have a preliminary objection, Lord.
Yes.
Now, my lord, the question is, my lord, here, my lord, see, my lord, that my construction is in no way going to disturb this person. Kindly,
Is it on government land?
question is, my lord, I have raised construction over my own land upon obtaining building sanction plan from the authority concerned. Question is, my lord, if they are not in any way, they have to go in public, file a public interest litigation that I am encroaching public land. I am disturbing public. How can they choose this forum, my lord?
Kindly come to paragraph 7 of my writ petition.
Then my lord, they have to choose that forum, go to the district magistrate, unauthorized occupants act.
Paragraph 7 of
None of them have now, without choosing any of those options.
I would suggest that the petitioner submits a comprehensive representation before the SDO. You will be given an opportunity of hearing. This court will not go into merits. Let the SDO decide. Yes, I'll record your submission.
Kindly, my lord, that I am occupying my own land and I have raised construction upon, I'm grateful. my
I'll
lord.
record this. Affidavit of service, none appears for the state respondents despite service. Mr. Dev, appointment regularized করুন। Copy service and direction.
ও কি বলেছে একটা গ্রাউন্ড নিয়েছে আনঅথরাইজড অকুপেন্টস অ্যাক্টের উপরে, এর পরের রিটে আপনার থেকে জেনে গেল, নোট করে রাখবে, ওইখানে একটা গ্রাউন্ড ঢুকিয়ে দেবে, যে চন্ডিদা এটা বলে দিয়েছিল, ঠিক আছে?
That the private respondent has raised unauthorized construction by encroaching upon government land adjoining their property, comma, thereby hindering user of their property.
And my lord, one more thing, my lord, that previously SDO has made one, my lord, inspection. You are satisfied. Thereafter, again, this filing of this writ petition, they made another.
That is not on record.
No.
But they have not brought all these things on record, my lord. That is the thing.
That is not the true fact.
Seeks to submit a comprehensive representation in this regard before the concerned authority and pray for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the private respondent, that the private respondents, that the private respondent has raised construction
করেছে
on
3 নম্বরে।
priority land upon obtaining sanctioned building plan from the concerned authority and has not encroached upon any portion of government land. Stop. Learned counsel further submits that the subdivisional officer.
SDO is not a party, but they need to add SDO.
Yes, three. Respondent number
No.
3, sir.
He is not the.
He is irrigation. My lord, kindly give me liberty.
Jamalpur irrigation subdivision?
He is not the.
That is
My
not,
lord, separate department.
He is-
My lord, that is the administrative. Head. That is to irrigation.
Oh.
In the department.
Officer, held an inquiry in this respect earlier and was satisfied that no portion of the government land was encroached.
I'm grateful.
Paragraph, learned counsel for the state respondents submits that the added respondent, added respondent, that the subdivisional officer Purbo Bardhaman,
Yes, my lord.
Purbo Bardhaman, comma, being the ninth respondent here, comma,
Subdivision.
be directed to consider the representation.
SDO Sador subdivision.
Bardwan Shodor subdivision.
আচ্ছা, ওটা subdivisional officer, Bardwan Shodor subdivision.
Yes, ma'am.
District Purbo Bardhaman.
Bardwan Shodor subdivision, district Purbo Bardhaman. Bardwan Shodor subdivision, comma, district Purbo Bardhaman. Be directed. Add করতে হবে আগে বলে দিচ্ছি। In accordance with law, বলুন? Paragraph in view of the above, the petition is disposed of with liberty to the petitioners to submit a comprehensive representation before the ninth respondent within 15 days. Within 15 days from date. Stop, the ninth respondent is directed to consider and dispose of the representation within 3 months from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondent, comma, in accordance with law. Disposed of which are then are
And
actually
communicate the
on
decision.
behalf of the-
And
Not
common,
necessary, you'll be called for evidence. It's a proceeding, you'll be called for evidence. একদম শুরুতে করুন, on prayer of the petitioners, liberty is granted to input the ওই যেটা বললাম সাবডিভিশনাল অফিসার ওই বর্ধমান সদর যেটা পুরোটা দেবেন, পুরো নামটা দেবেন as respondent number 9 in the writ petition. The cause title of the writ petition be amended accordingly.
I'm grateful.
কারেকশন করি না স্যার কারেকশন করি দিয়ে দিচ্ছি
Correction হবে।
এই সেকেন্ড
His lordship's affairs accordingly. The witness, my lord,
Not
we could
available.
not, my lord, reach him after this poll. My lord, he was also, my lord, he was contesting from one, my lord, municipality.
He's safe and sound.
My lord, cannot reach him. So, my lord, it's item number 5. I would only request lordship to keep it after 3 weeks. There was another election petition where I was to lead evidence today. I had to, my lord, pray for a similar relief there, my lord.
Other side, you are.
Yes, my lord, I am mentioning.
একটা order for election petition. On prayer of the petitioner, the matter is adjourned. Now let the matter appear under the same heading as requested by learned counsel for the petitioner on. As requested to Polygon. Let the matter appear under the same heading on end of August.
His lordship may keep it, my lord,
25th,
third week of 24th or 25th, yes.
24th is a Thursday. So
So
24th of
24th,
August.
my lord.
24th of August, 24th August 2023, as requested by learned counsel for the petition.
Grateful, my lord.
It will appear. At 3:30.
What?
Will it appear at 3:30? Let me see for the timing.
3:30, yes, lordship. Otherwise, my lord, we will be here. If my lord, lordship's
Yes.
other business is over,
Not
we can.
fixing any time, yes.
Original side, item number 1.
Service. Who is appearing for the contemner? It is not served upon the contemner, it's served upon the office. You have to serve Probit Chattopadhyay.
Probit Chattopadhyay, the name is not there.
You have not served Probit Chattopadhyay. You have served the State Transport Authority and he may not be informed. Please serve and come.
Yes,
Contempt has to be served.
yes, but this is personal allegation. The contempt has to be served.
And the office may not inform him also. Since service upon the alleged contemner is not complete. Comma, let the matter stand over till.
Well, let it be taken up on next Thursday. Lordship, and this is a case where the vehicle is standing idle only to permit to be given. Their allegation is that the tax has not been paid. My lord's observation is that the documents are there already. It is prima facie satisfaction is that the tax has already been paid. That's why, my lord.
Contempt is only compliance. They cannot say.
Yes, no, they have taken compliance is that they have taken a stand. That is our issue. They passed an order as if sitting in appeal of my lord's order. That is, your lordship can see the contempt application. They have taken a stand. But the decision taken as if sitting in the appeal.
27 July. Thursday week. Stand over till 27 July. 27 July.
Only one thing, your lordship kindly come to the affidavit of service.
Yes.
There, the name is there and received it by the secretary. But the name is there.
Not by the secretary, by the department.
Please say
Received
it.
by the department. It should be received by that person.
Then your lordship kindly do one thing, if possible, the direction to be given to the, because they only received from the counter. So directly the secretary, the seal of secretary.
Served by name. Issue served by name.
By post.
By name of the person.
Yes, that is there, your lordship can see. It has been served on
Served by speed post or something, because like this, you serve on the office only.
mine.
You don't serve on the particular person. If you serve individually, then he'll receive.
Fine.
By name, by speed post.
By name.
Next.
Item number 2.
Item number 2, you got the petitioner
No, no, and for the next.
in the next matter. Mr. Ghosh is appearing in this matter. no?
Next matter, which is there.
Oh, this is a different matter. No one is appearing. None appears for the petitioner. No accommodation is sought. Paragraph, let the matter appear under the same heading on 10th August.
I think number 3.
My lord, 3 is, my lord, senior friends matter, my lord, where he had already concluded submissions. 3 and 4 were heard analogously, my lord. My lord, we had also indicated, my lord, the factual background as to the matter. 4 is my writ petition. My lord, we
Only
had
one
already,
thing, my lord, before my lordship starts, my lord, only one thing I'm submitting. That I made my submission in respect of my the case, stating that the authorities have themselves, my lord, have decided to revisit the entire issue. And I have also made submissions so far as his case is concerned on the last occasion. But your lordship also hearing, my lord, another the application, interlocutory application of my land of regarding my depositing of the amount.
yes.
What is the interlocutory application about?
That interlocutory application regarding
It's for
my
deposit of the
asking for, my lord, asking
1
for
crore 18 was admitted amount. We wanted, my lord, the admitted amount be deposited in court, because that's a normal,
asking for
very,
that is whatever the amount, my lord, to be paid under the order of the first daily collector, which is, my lord, under consideration before lordship, my lord. They are asking that that amount to be deposited with the Registrar General. That is the, my lord,
that is the scope.
they have made this pair. On earlier occasion, they made the pair. I submitted, my lord, that after hearing whatever the directions follow, my lord may pass an order. Then they made the same prayer before the division bench where the contemplation is there. The court said if it is permissible under the law, you could make an application.
Since you're dealing with the main matter itself, let's deal.
Ma'am,
with
let
the
me Mr.
entire
Back.
matter.
My lord, what about it? There's the interlocutory application with regards to
The entire matter is being dealt
yes,
with.
the
already.
entire matter. Yes, yes, my lord.
They had finished their argument.
Yes.
No, that I'm submitting with regard to that.
The application.
No, they argued with your lordship on the writ petition.
Writ petition, I submitted, my lord, regarding I have moved the writ application. I have also made submission on your application.
Correct, correct. So
That's right.
I
That
can,
is I'm pointing out, but there is another application that is with regard to that I have not made
I am
any
also addressing your lordship on both issues together. His writ, my writ, and their application.
No, so far as the application part, my lord, I did not make any submission. That
Application not necessary.
not necessary, then it's all right. Then it's all right.
Public থেকে রিট ডিসপোজড অফ সেটা থেকে আপনি কি করছেন? আমি করছি। একটু চালাবে তো? হ্যাঁ, সেটা করে তারপর আমি ডেপোজিট করছি।
Now, read them.
একটু চালিয়ে দিস কোন একটা মিস করলো।
But I had addressed your lordship elaborately on the fact
Yes.
on two things. My lord, just two things I'll recapitulate. There is one order of 1 crore 18 lakhs.
that has been challenged by them on the ground that the basis of valuation is incorrect. Why have you looked at X property, Y property? Why haven't you looked at Z property? All of that. Then there is a revision of 1 crore 18 to 1 crore 64. 1 crore 64. That they say that this has been done with the blessings of the higher authority. The court had directed this particular person to do it, and that person has not done it. He has taken the dictates of his superior. And I had tried to show to your lordship that this is possibly factually incorrect, because this is departmental procedure. And from 118 to 164, he has done everything by himself. The calculation was by him. The basis was by him. It was only on the basis of a government notification that the LA collector was asked to revisit his calculation. So it was just a numerical thing. The basis of assessment, which was the requirement of the revision bench order, was done by the first LA collector. Now, after this order was passed, when they sat on it, we wrote a letter that disbursed this amount of 164 to us. They filed the writ petition. After the writ is passed, an order is issued by the LA collector saying that I want to now go back and measure the property, and therefore with the measurement these arrears and all will come into effect. This second part of it is under challenge in my writ petition. Now, just 2-3 issues I addressed your lordship on the first day. One is that the order by which 1 crore 18 lakhs was arrived at is a very detailed order. Every aspect has been looked into. The corporation was heard. There, before the authority, the corporation made no suggestions, no recommendations, no objections. Nothing was stated. Please do not rely on me. I'll show that page. But if your lordship looks at page 71
Of this?
of their writ petition. This is the impugned order. Exactly. 71 is the impugned order. Kindly have a look at 73. On the other hand, the respondent. 73, page number 73.
73.
Yes, ma'am. First line.
Yes.
On the other hand, the respondent, that is Kolkata Municipal Corporation, did not provide any rate of rent in support of their claims.
Give me a minute. 73 of 2206.
Page 73 of their writ petition, no? 2289.
Yes. Considering the above, in order to determine this is
Huh? Just above that, just the starting line.
on the other hand.
On the other hand, the respondent, that is Kolkata Municipal Corporation, did not provide any rate of rent in support of their claims. So there, before the authority, they had nothing. What should be the rate? What should not be the rent? Now kindly turns over to 72. That I had placed this on the last occasion, but I'll beseech your lordship to give it a cursory glance, just a line-wise glance at the detailed analysis on which everybody was heard. We gave a rate of rent that should be applied. Kolkata Municipal Corporation gives nothing. Every building that has been considered, that is going to be taken into consideration, everything was looked at. Exactly, my junior is right. Why a certain building will be looked at? What was the rate of rent? The similarity, everything. If your lordship beseeches, desires, just 2 pages. Can I just place it for your lordship's convenience? One at page 72. Represent his third paragraph at page 72. Representative of both the appellants and KMC appeared in the hearing on 28 September. Learned advocate for Rameshwar property, which is me, as in for Rameshwar, submitted a set of documents in connection with determination of occupation charge of the subject premises. He submitted a valuation report prepared by a private valuer, where it was stated the rental rate for such type of property, which is not property maintained by the occupants, is 40 per square feet per month in the year 2015. However, the basis for such rate is not explained therein, so such rate of rent can't be taken into consideration. The appellants have also submitted 2 registered lease deeds dated 17th October 2015 and 3rd January 2013, wherein the monthly rate of rent in respect of 20390 square feet area at premises number so and so was fixed at rupees 113 per square feet on 1st April, and respect of 16150 square feet at premises number Netaji Bose, Subhash Bose Road, the rent was 105 square feet as on 1st February. The rates of rent of these 2 premises are not comparable with the rates of rent on 42 Ripon Street because of the fact that both the premises Netaji Subhash were let out to private entities. This is important, whereas the premises 42, this is the subject premises, was requisitioned for public purpose. The very objective of hiring these premises are altogether different. One is for commercial purpose, that is running a business for making profit, and the other for rendering a public service. Hence, the reference rate provided by the appellants can't be taken into consideration. On the other hand, the respondent, that is the Kolkata Municipal Corporation, did not provide any rate of rent in support of their claims. Considering the above, in order to determine the occupation charge at premises number 42, I will be laying some stress on this henceforth. As per government policy and guidelines, the LA collector has to rely upon 2 government orders bearing so and so dated 30th August 1993 for the period from 20th January 2000 to 29th April 2013, and the other dated 29th April 2013 for the period from 30th April 2013 to 15 December 2013. Rents of at least 3 comparable premises are generally taken into consideration for fixing the rent of any premises. Accordingly, at the premises 32A, 8B Lindsay Street. Well, this is important because earlier, your lordship will recall, kindly make a note of at page 51. Earlier, the assessment was 74 lakhs. There they had taken Lindsay Street, this particular property, and no other property. This valuation was challenged by us. So the court held that this was done in a very hurried manner. They're taken into consideration only 1, and there's also no basis on which 74, therefore 74 was set aside. Now the pleading in the writ petition is that why 8B Lindsay Street along with 2 others. I'll show that pleading. So 8B Lindsay Street was there. 2 other premises in terms of these 2 government orders have been taken into consideration, have been found to be suitable for comparison. There are a lot of common features among these 3 premises vis-a-vis the premises of 42 Ripon Street. The locations of all these 4 premises are in prosperous areas of Calcutta. They have almost similar nature of construction. May I beseech your lordship to mark these, my lord. Provision of amenities are more or less same, and the rents were fixed almost at the same time. So 4 ingredients are put into this recipe for making this assessment. Most importantly, all the 4 premises were requisitioned for public purpose. Hence, it is that's the 5th one. Hence, it is found to be very reasonable, fair and justified to arrive at rent for premises number 42 Ripon Street, averaging the rent of these 3 premises. Now, I'm not troubling your lordship with the rest. First line, 32A Brabon Road, Kolkata. There is 8 to 9 lines of assessment of what the rent ought to have been for that property. Similarly for Lindsay Street and again for Chorongi Road. Then the land acquisition collector makes a total, divides it by 3 and applies that rent for this particular property. Their challenge to 118 is on the ground that not all parameters have been looked into in assessing the rent, because other properties also should have been looked into. And why have these 3 properties been looked into? This is the challenge to 118. 164 I'll come to later. But with this kind of an analysis and by a person who is competent to make this analysis, courts under judicial review will not be invited to make such an assessment. What will be the rent of a property at Lindsay Street? What will be the rent of a property on 31 Chorungi Road and Brabon Road? And why will the rent of Victoria Memorial not be considered? And why will the property in Southern Avenue not be considered? This court under 226 is not equipped to, has never been constitutionally required to do. All that the court assesses under 226 is the decision-making process and not these parameters which have been, because this has been best left to the authority that is in a position to decide. That's my first legal submission on the basis of this. Everything that I argued today, I'm carrying judgments, I'll substantiate, I'll buttress them with decisions. But this challenge, therefore, as to why, and I'll show the challenge. If your lordship looks at their grounds that they've taken, kindly have a look at page 19. (18H) also your lordship can see. 18H. Moreover, page 18, paragraph 8. Moreover, no reason has been disclosed why rent compensation payable to the respondent number 4 should increase by a whopping 20% every 3 years. No reason has also been mentioned why the monthly rent compensation payable in respect of subject premises for the year 2000 will be 960 per square feet, not 845 or 6.28. Now turns over, my lord. Page 19B.
Yes.
For that, the 3 properties whose rent has been taken into consideration for determination of rent of the subject property, Chorungi Road, Brabon Road, Lindsay Street, are located in prime business area or commercial areas, while the subject premises is in a congested slum area. These issues today under 226 can't be raked up. This is not, pardon my language, the job of a writ court. This is really calling the writ court to exceed its jurisdiction to ascertain and assess what will be the rent, where the property is going to be situated, what will be taken into consideration. Then your lordship's work will never end. If this is his ground of challenge for 118, first, therefore, these are decisions that are best left to the authority that is competent to make such assessment. These are jobs or works that partake the character of expert assessment, which is best left to the expert who is designated to do the job. Secondly, these are disputed questions of fact. Whether this locality is in a congested slum, whether Brabon Road is high-end commercial, where is the location of 31 Chorungi Road? Where is the location of 8B Lindsay Street? And therefore, what will be the assessment by which the land acquisition collector will make? This, in my respectful submission, is a disputed question of fact and therefore cannot be the basis of invocation of a writ jurisdiction. Second, my lord, if your lordship looks at, comes back to page 74.
Yes.
So there is an assumption of the rent. Then there is an entire calculation that is made at page 74. As the at last paragraph, as the corporation already paid 74.31 as occupation charge for the subject period. So now 118 minus rupees 44 is required to be paid to Rameshwar Properties by the corporation. So this is with regard to the assessment of 118. Kindly turns over, my lord, to 75. There is a detailed calculation of how this 118 has been arrived at. Every figure, every feature, and the period is stated here in paragraphs 1, 2, 3. Then there is again a box where he makes this. If your lordship now looks at one very important page, kindly have a look at page 71. So the challenge from 118 to 164, I'll show what the challenge is. Now, your lordship will turn over to 76.
Yes.
To the LRC and Principal Secretary, recalculation of a office memo number so and so, that a calculation of occupation charge was made in respect of from 20th January 2020 to 15 December. By this office reference, calculated amount of 118 was sent to you for kind vetting and authentication. 19 February 21, first land acquisition collector has advised to recalculate the occupation charge as per formula shown in said memo to the same in triplicate. Now a fresh calculation has been made. So all that has been done is the formula has been sent by his superior by way of a memo that has been issued by an authority that is higher. Now, one thing I will request your lordship to note, that none of these documents were actually forwarded to the petitioner or the corporation till the final assessment of 164 was made. These documents at page 76 and at page 71, kindly have a look at 71 once. Last paragraph.
Yes.
The calculation sheet in annexure A, as well as the report, is enclosed herewith for your kind vetting and approval. The first land acquisition collector has to submit the calculation to the appellant and respondents immediately as per court's direction. Kindly have a look at the copies that have been enclosed. Your lordship will not find that this copy is been marked either to me or to the respondent here. Similarly, with regard to page 74. Now, what comes to both the parties is at page 80, where the corporation is given the notice by the first land acquisition collector to make this payment. And it is along with this that these memos are being forwarded. Now, this document at page 71 and 74, by which internal communications happen between the department, cannot be the basis of a challenge before a writ court under 226. That's my second ground. These are internal communications and are not justiciable at the instance of either of the parties under 226. Communications made between two officers in a department cannot be the basis to question an order, because this is between one officer to another officer, which ultimately results in the order at page 74. The internal communication can't be a basis to challenge the order at page 74, because internal communications are not justiciable under Article 226. Third, last point, my lord. Your lordship will find at page 80 80.
Yes.
That this is a document that the first land acquisition collector, Kolkata, issues to the Commissioner, Kolkata Municipal Corporation, directing them to make payment of 1,62,43,175. You will find that figure in the first paragraph from line about 5 from top. The assessed amount was sent for vetting and authentication to so and so. After proper scrutiny, an amount of 162 was vetted and authenticated by LR and RR department, and same was communicated by so and so to the joint secretary. So this demand of 162.43 is now being made by a notice of 12th of August 2021. Now, once this order is issued and a demand is made, this administrative authority, which is the first land acquisition collector, and if I give him slightly more credit for what he's done, because his order affects civil consequences, I'll say that he is a quasi-judicial, which is really not. It's an administrative order. So this administrative authority, once he issues this order of 12th of August 2021, he becomes functus officio. He has no right unto himself to recall this order unless it's set aside or challenged. So this notice that is under challenge in my writ petition, that I'm withdrawing it for the purpose of measurement, that is not available to him anymore. Now, with regard to, Lord, kindly have a look at two documents. And factually, I'll end here, Manoj. Lordship will have a look at page 51 once. Kindly have a look at page 51. This is the sum of assessment of rupees 74 lakhs. At the left-hand column, your Lordship will find the area that is mentioned. 7031, 7031. Now kindly have a look at page 71. Not 71, my lord. I'll not trouble your Lordship with the same document again. At page 74. Seven zero three one. Sorry.
Yes, the same premises. Yes.
Same area. Turns over, my lord. Page 75, again, your Lordship will find the same thing. And again at page 71, your Lordship will find 7031. Now, most importantly, the area that was assessed for compensation to be payable at 74 lakhs was 7031. Now, why does the clock stop ticking in 2013? Because in 2013, the land gets acquired again under Land Acquisition Act. Now, there, my premises gets acquired, which is also an admitted position. Now, kindly have a look at the notification issued under section 4, section 6 in that. The area of land mentioned.
This was in 2013.
This was in 2013. This is an admitted position that I am entitled to get compensation till 2013, because 2013 onwards, my land has been acquired. This particular premises is acquired. And the land acquisition notice also, I'll just show that. I'll show that document to your Lordship in a minute, Vinod. Yes, yes. Look, kindly come to page 43 once. This is form of
3D.
Form of notice under section 4. Kindly turn over, Milan. Premises 42 Ripon Street at page 44, Milan. This is a notice under section 4. At 44, premises number 42 Ripon Street. At the left-hand column, your Lordship will find under land schedule.
Forty-two Ripon Street.
42 Ripon Street. Kindly have a look at the far end of that page, square feet.
703.
So today, how shameless is it that after the corporation files the writ petition, state wants to revisit on the ground, they want to go and measure it. That is the ground. Then they want to revisit it because they want a measurement of the property. The corporation wants to go by the 74 lakh assessment, which is 7031. All assessments are 7031. I'm disregarding it. Their own notification under section 4 makes the land at 7031 square feet. There can't be any further revisiting of the land measurement. But if your lordship just takes up our writ petition once,
Yes.
our writ petition, my lord, which is
2380.
yes, page 158 of them.
Yes, 158.
This is the offending letter in my writ petition. 19 July 2022. Following the filing of 2289 by KMC in the matter, read with order dated 28 January of the Honorable High Court APO, that the order I found, showed your lordship. The necessity for inspection of premises number 42 Ripon Street with a view to determining the actual rentable area of structures as well as the vacant land has arisen. Besides, detection of some errors in calculation of occupational charges requires revisit of the calculation process of mean profit occupational charge. Basically, if the area reduces, then the computation will also change. So they want to go back and inspect. And why have they done that? At least here they're honest enough to say that because this writ was filed by the corporation. So the writ get filed by the corporation, they take out this notice. So now the state and the corporation on the same boat, and a person who has been fighting for occupation for that occupational charges for 13 years is now going to be left high and dry. Could I just pray for one indulgence? Keeps it next Thursday. This factually, what is there, I'll make a note and cite the judgments on that day. And I can then, I'll give an advance copy to the corporation. They can distinguish it on that day itself.
Has to reply.
Yes, he has to reply. So I'll give an advance copy to him. That is only if he says that he will reply on the next day. If he's going to take a time on that day also, then it's
There's no question of also you have to complete first.
I have to. It's just more convenient for the bench in my assessment if the facts, the page numbers and the proposition is given in a note. Otherwise, this is slightly factually heavy. It's only going to be difficult for your lordship to keep a track. And I will also lose track of it, more importantly.
I've taken a note. Well, give it to me.
Just a note with the...
Takes that exercise, he can indicate also the point he has stated here in a nutshell.
That's right. That's what
Then
I want
I'll
to do.
look into it and answer to that.
That is what I intend to do.
Bullet points and you.
I'll put in a bullet points along with the judgment. And then I hand it over to your lordship on Thursday.
You want to come back next Thursday?
Yes, Manoj. And I'll give an advance copy of that note to my learned senior friend.
That is 20th.
20th, yes, Manoj.
Very good.
Only request to my learned friend, let them not make any trouble before the division bench. In the contempt,
No, that's a different thing. He's not gotten a stay here. What
Not-
I do there is the 20th.
That's next Thursday.
Yes, I have something fixed already at 2 o'clock. Could it be a little later, my lord? 2:30 or 2:45?
Let it appear in the list. Or will you come up on 27th, the next Thursday?
No, let it appear in the list, my lord. I'll take my chances. I'll come back.
Third learned counsel for the Petitioners in WPO 2380 of 2022. Paragraph. Let the matter appear under the same heading for further consideration on 20th July, next Thursday.
Very grateful.
For it.
Item number 6.
6. Five was 6
Jana was there.
You are for the petitioner?
No, Malad, I am the added respondents, which is Jana was there, Malad, these.
Petitioner, no one.
So we are, Malad, I am suffering, Malad, interim order.
All the 3 matters are Mr. Jana's.
Yes, in 2 matters I have added, and in 2 first and second matter. And your lordship was last, they allowed the application for addition of party. Then, Malad, I made an application for further, Malad, seeking, Malad, the modification of that order, because, Malad, the whole, Malad, the grant has been stayed.
The order has expired on 6th June, I find.
So the interim order expired, Malad, but the court, Malad, that cannot be taken as but the interim order expired, because I am not getting the benefit of that interim order expired, so I have got the permit.
Have you tried to? Because it has expired on 6th June.
No, that has not been expired so far. Your lordship kindly see.
7.
Your lordship kindly. In my application.
2797.
My name, I'm appearing for the state respondent, my
No,
lord.
your lordship kindly see in my application.
My
But
lord.
that is which applications? Your lordship's, my lord's orders is there at page 30 of my application. It has not been expired. My application.
2797. WPO 2797.
GA2, yes, WPO 2797. My lord's last order, order is of 18th of May.
I am for the petitioner.
From there, the interim order extended. And I think, yes, interim order extended till 29th, then 31st July.
Last order.
I have annexed in my application, GA2. But that is still
Sheet is not there.
mile. In my applications, I have annexed these last order. That is of 18th of May, 2023.
That's all right.
But that is extended till 31st of July. So,
You are for the petitioner. Ready? Yes.
Your lordship, my lord, the
My lord, application, my lord.
petition be heard.
We heard, my lord.
Retribution, my bid has been exchanged. Your lordship, retribution can be heard.
Yes, yes.
My lord, your lordship first consider, my lord, the first order 13 October 2022.
আমরা তো reply দিবি।
My lord, I'm praying one thing, my lord. My lord, kindly give, my lord, 2 days time, my lord. Can it be possible, my lord? My lord, today, my lord, I just forgot.
I was reading this from your face. That's why I asked.
My lord, I just forgot to file, bring file, my lord.
You didn't file.
Yes, my lord. My apology, my lord.
Next
My
Thursday.
apology, my lord.
I have not.
Only whole predicament is just my vehicle is standing because I have the
My
success.
lord,
I am the successful candidate. The interim order passed way back in 2022. So I am facing this problem. I submitted documents and fees thereof. And then only they communicated.
In October 2022, interim order was passed.
Yes.
So there
Yes.
is no question for my lord, the suffering from.
Yes, then from yes. The interim order passed.
Election process, my lord, the.
But that is right. I am not on that. But the interim order passed after I got the offer letter. Your lordship kindly see my application.
Your submission was considered before the interim order was passed.
I cannot.
You were on record when the interim order was passed.
No.
You did not, after that you have been added.
Yes, because the authority communicated as because the interim order, we are unable to issue the permit in favor of myself. So, my lord, he has not added with the party. I was the, my lord, kindly appreciate, he hasn't added with the party there in the petition.
1 week next Thursday. All the 3 matters are similar.
Similar. The
No.
same
Take the
resolution.
matter over next Thursday. On prayer of the state respondents, the matter is adjourned.
I'm looking.
Let the matter appear under the same heading on next Thursday.
Only one thing, my lord, my lord,
Separate orders, in the same order.
only one thing, my lord, I also use my lord affidavit in opposition because I have added. So, my lord, only 1 or 2 days time may be given. I will have the in the meantime. my lord, In the
Shall I add, Kurun?
In the-
Affidavit in opposition be submitted by the added respondents in the meantime
Mine.
upon service of advance copies to the
Mine.
others.
Mine.
Other parties. Same order.
বাকি আমি জানি না ভাই বল।
আপনাদের নামগুলো একটু
দিয়েছি আমারটা স্টেটে দিয়েছি দেবজিৎ মুখার্জি
স্টেট ফরটি
স্টেট
তিনটেতেই petition থাকে। তিনটেতেই
হুম?
6 and 8
দুটোতে আছে।
added respondent. তিনটেতেই 6, 8, 7 and 8.